Or with the consent of the other side.
That is my lord. I beg to mention item number 10. I'm on the behalf of AK Prakaska. And this matter may be raised on 16th of November. Opposite leading counsel is from government.
You're correspondent or?
I'm from the petitions. On the behalf of AK Prakaska.
Learned Counsel Miss on
D.
behalf.
Rilo.
D. Ilo.
Rilo.
On behalf of Learned Counsel for the petitioner, respondent,
AK Prakaska.
Miss A.
Petition.
Petitioner. Oh, Learned Counsel for the petitioner with the consent of the other side has prayed for adjournment. This is the matter on 16 November.
16th November.
Lordship, I beg to mention item number 2 on behalf of D. Panging. Lordship, the leading counsel could not appear due to personal difficulties. I have obtained consent from the other side.
On behalf of,
D. Panging.
I just mentioned.
Due to personal difficulties. Lordship, due to personal difficulties.
We have taken consent from the other side.
Yes, Lordship. Matter may be taken up after
Learned Counsel Miss on behalf of Learned Counsel.
RC
D.
Lawang.
Panging, with the consent of the other side has prayed for the respondent.
For the
For
respondent.
the respondent with the consent of the other side has prayed for adjournment. List the matter
Puja break, Lordship.
after puja. List the matter after vacation.
Lordship, I have another matter to mention. Item number 7 on behalf of D. Panging. From the respondent side.
You have no objection?
No, Lordship. Lordship, there is a interim order. Lordship. May continue.
Ekata liquidity or khali interim order will remain in force legally. Interim order shall remain in force till the next date.
Lordship, one more item. Item number 15. From the petitioner side, Lordship. After puja break.
A2 AK khali instead of respondent is a petitioner legally. Item number 15. Adjournment.
After puja break.
Your Lordship, I would like to beg to mention item number 1. As the leading counsel is busy in other court. We
For
need,
time being or?
no, we need
Passover.
some more time.
Okay.
It may be listed after vacation.
Learned Counsel for the petitioner has prayed for adjournment. List the matter after vacation. Yes.
My lord, I would like to mention item number 5 for adjournment. The learned person is out of stations.
Learned Counsel for the petitioner is out of station. List the matter after vacation.
My lord, in item number 8, the leading counselor is physically unwell, so I'd like to pray for the
Learned Counsel
another.
for the
Yes.
petitioner.
Yes.
Mr. D. Laji
Yes.
is not well. List the
Yes.
matter after
After
vacation.
we do- Like,
May it please your lordship. Lordship, in this matter, I'm challenging the order passed by the district judge Alo, wherein while entertaining a letter of administration, your lordship, he had gone beyond the jurisdiction while staying the order of the Kaba, your lordship, which was never challenged, your lordship. Now, if your lordship will come to, there was a dispute of a property, your lordship, between the respondent and the petitioner, your lordship. Now, if your lordship will come at page number 24, your lordship. Now, if translated copy is at page number 26, your lordship. A Kaba was held wherein the same property was divided into two parts by the Kaba members between the petitioner and the respondent, Your Lordship. Subsequent to Your Lordship, since there was no compliance of the same Kaba, Your Lordship, the respondent was not allowing the petitioner to take that. Another complaint was filed, Your Lordship, will find at page number 28, Your Lordship. The translated copy is at page number 29, Your Lordship. Your Lordship will see
Subsequent, this is subsequent or? another
subsequent, Your Lordship, because
Regarding the same property.
same property, it was already divided, Your Lordship, and subsequently, since they were not allowing to take the rent, Your Lordship, another complaint was filed before the Kaba, Your Lordship. Now, Your Lordship will find at page number 29B, Your Lordship. Cognizance was taken of the complaint, Your Lordship, and Parwana was issued accordingly on 28/2024, Your Lordship. Thereafter, Your Lordship will find it page number 31, Your Lordship. Page number 31, Your Lordship. The respondent had filed a letter of administration, Your Lordship, with regard to the same property. Now, Your Lordship is well aware that in letter of administration, only the claim is with regard to declaring someone a legal heir, Your Lordship. This is not a petition wherein Kaba decision in any form were challenged, Your Lordship. Subsequently, we have given our objection. Your Lordship will find our objection at page number 49, Your Lordship.
Objection against this.
Objection against the letter of administration, Your Lordship. The main ground of our objection was with regard to the maintainability, stating that the Kaba has already adjudicated upon the issue on the same land, Your Lordship, and therefore this LA does not lie, Your Lordship. Either they'll have to challenge the Kaba order. Now, if Your Lordship will turn to page number 73, Your Lordship. If I may read, Your Lordship.
Yes.
Mr. Atta, learned counsel for the applicant appeared. Meanwhile, MS so-and-so learned advocate appeared on behalf of Sri so-and-so, claiming to be the eldest son of late so-and-so. Ms. So-and-so had filed an objection petition in this application with a statement that matter has already been settled by the Kaba. The copy of the Kaba decision is enclosed in the objection petition at so-and-so. Now, the court was apprised. During filing of the LA, they had not disclosed about the same. So the court was apprised, and therefore, any reply to that objection was to be put up by the respondent, that is the applicant in the LA application. Now, what has happened, Your Lordship? Subsequently, another Parwana was issued with regard to the complaint that was pending before the Kaba, Your Lordship. Your Lordship will find at page number 115.
Just a moment. Just a moment. Yes.
At 115, Your Lordship will see. I deeply apologize. Your Lordship will come to page number 105, Your Lordship, annexure 6.
105.
Annexure 6, Your Lordship. Since that Kaba was never being challenged, Your Lordship, there was no stay order of any kind, Your Lordship. Therefore, it was proceeding accordingly. Now at page number 105, the translated copy is at page number 106.
Yes.
Your Lordship will see another Parwana, a reminder was issued fixing the Kaba on 17th 10th of 2023 while entertaining the complaint of the petitioner, Your Lordship. Thereafter, Your Lordship will find it 108 page number. An IA was filed in the LA application by the respondent, Your Lordship. Your Lordship will see the cause title, Your Lordship. An application for restraining the head Gaon Bura of A village to conduct Kaba on 17 October 2023, Your Lordship. Your Lordship will see this IA was filed in the LA application. There has not been any challenge to any of the kaba. There are two kabas, Your Lordship. One was already decided and subsequently one was in the proceeding, Your Lordship. Have not challenged. In an allay application, they have filed an IA praying for restraining the Gaon Bura from conducting the kaba. Thereafter, interestingly, Your Lordship will come at page number 118, which is the impugn order, Your Lordship. This is the effective paragraph. It is paragraph number 7, page number 120, Your Lordship. If I may read, Your Lordship.
Yes.
Considering the above facts and as per the provision of relevant law, this court is of the opinion that the applicant has made out a case for passing interim order in the case. Accordingly, it is ordered that the Kaba Parwana dated 5/9/2023 issued by so-and-so in charge head Gaon Bura A. Alo shall remain suspended till the further order of this court. Meanwhile, thereby the Kaba meeting scheduled to be held on so-and-so between so-and-so shall not be conducted. This is what the impugn order is, Your Lordship. Now, Your Lordship is well aware that Kaba, a village authority, it's itself an entity and it's a court, Your Lordship. A court where no challenge of the Kaba decision, no challenge of the Kaba proceeding is being made. Only an allay application where a prayer for declaring someone as a legal hire is made, an IA application is being filed therein to interfere with a court proceeding that's going on, Your Lordship. And even the lawyer, even
the appellate authority.
yes, Your Lordship. Either they should have challenged the Kaba before the appellant authority, Your Lordship. But in an LA application, how can an IA be filed for restraining search?
Invitation notice.
Yes, Your Lordship. And meanwhile, Your Lordship, interim may be granted for this.
Item number 16 or 17.
16, Your Lordship.
You understand of that interim order?
Yes, Your Lordship.
In
Because
that, interfering with the,
Kaba
decision.
proceeding.
but if the Kaba will proceed, then there'll be
No,
jeopardy.
no, not Your Lordship. Now, if Your Lordship will see, first Kaba was held.
He can go for appeal. but-
Yes, they have not appealed on that Kaba order, Your Lord. Second Kaba proceeding is being held, Your Lordship. Now, my main preliminary objection with regard to LA, wherein they have not even apprised the court that a Kaba
In
proceeding is.
LA, what is the benefit you are seeking through the ALA?
No, LA has been filed by the
Other party?
other
What
party
is
on the
benefit?
same disputed land that has already been decided upon. Now, the in LA application, my preliminary objection itself was it is not maintainable since already adjudication has been done with regard to the same land.
Both the parties are legal heirs of one.
Yes, this is personal.
Had Miss T. Jenny Leonard counsel for the, this is a petition, no?
Yes.
Petitioner, the petition is filed under the learned counsel for the petitioner who has filed an application under section 115, read with section 151 of the Code of Civil Procedure and Article 227 of the Constitution of India, seeking quashing of the ex parte order dated 9/10/2023, passed in IA number 2/23, arising out of LA case number 6 of 2023, pending in the court of the District Judge Alo, West Siang District. It is submitted that regarding relating to the same plot of land, a Keba decision was held. The Keba decision was already held.
Yes, Your Lord.
Keba decision was held
On 16/7/2023,
on 16/7/2023, which page?
page number 24, Your Lord.
Which is marked as annexure 1 of the petition. comma, but the respondents, instead of filing an appeal against their decision, preferred petition.
Your lordship, prior to that, your lordship will come to annexure 2, your lordship. Sequentially, your lordship, the complaint, another complaint was filed on 13/8/2023. This is the stay was made in this. Kappa proceeding.
Yes.
Yes, at annexure number 2, page number 28, your lordship.
Page number
This is the
28.
proceeding that they have stayed, your lordship. This was filed prior to the LA application was filed here.
Okay. The respondents. This is by the respondents,
This by petitioner, your lordship.
by the petition.
Yes,
Okay, the KEBA decision was initiated by the petitioner,
yes, that was already passed in our favor, your lordship.
then.
Now, this
subsequent-
complaint was made because after,
KEBA was not.
no, after a month, when we went to take the rent of that shops, which was divided in our favor, your lordship. It was informed to us that they have
Okay.
forcefully taken, and therefore another complaint was made.
When the petitioners were petitioners or petitioner,
Petitioner, your lordship.
when the petitioner was not allowed to withdraw the rent of the shops, which was, and when the respondents had forcefully taken the rent, the petitioner had filed another petition,
Complaint, your lordship.
another complaint for a KEBA,
On
To call
13,
for a KEBA.
yes, yes, yes.
to call for a KEBA hearing,
On 13/8/2023, your lordship.
which was again decided on 13/8/23,
23.
13/8.
13/8/23 is the complaint. Your lordship will find it page number 29, your lordship.
Okay.
Complaint. your lordship.
28, it is 38. okay.
13/8/2023, your lordship. Subsequently, notice was issued on 28/2023, your lordship.
And notice was issued on 28.
2023.
2023. The complaint is marked as annexure,
Complaint is marked as annexure 2, your lordship.
annexure 2. So thereafter, then they have filed,
LA application.
the respondents thereafter filed
Page number 30, your
filed an
lordship.
application for letters of administration relating to the same
Same disputed
property.
land. Yes,
disputed property.
yes.
It is averred that in that while the LA case was pending, the respondents again filed an application which was registered as interlocutory application number,
2 of 2023.
which page? Two of-
Page number 108.
and- And the petitioner filed an objection against this interlocutory application.
No, no,
Where-
no, your lordship. We had filed our objection in the LA application, your lordship.
Oh, okay.
The LA.
That is not required.
Yes, that's not
It's
required.
not like a objection to Gotha. The
It-
petitioner is aggrieved by the order passed in this interlocutory application,
Yes,
number 2/2023. Wherein the learned district judge stayed the KEBA proceeding.
yes. Your lordship will find it page number 120, your lordship, paragraph 7.
Parwana has been stayed,
Your
not the
lordship,
proceeding,
no, your lordship, the proceeding has stayed, your lordship.
suspended. Okay. Okay. KEBA proceeding dated 5/9/2023.
Yes, 5/9/2023 is the second parwana, your lordship.
Proceeding scheduled to be held on
17,
5/9/23 in Hare, proceeding scheduled to be held on 17/10/2023. I have considered the submissions of the petitioner with circumspection, the petition, circumspection. The petitioner has made out a case for interim stay. It is submitted by the interim order. Stay, no? Interim order. It is submitted by the petitioner that in a proceeding for letters of administration, the proceeding of another forum, that is the forum of the village authority or KEBA, cannot be suspended. Stop. Issue notice to the respondents. Meanwhile, the order of stay. So you want the order of stay to be vacated.
Yes, your lordship.
Where is your prayer?
Your lordship will come at page number 21, your lordship. It starts with 20, your lordship.
Please read the prayer portion.
Your lordship will. In the premises aforesaid, it is thereby respectfully prayed that this honorable court may please to admit this petition, call for the recourse and issue notice calling upon the respondent to show cause as to why the impugn or ex parte order dated so and so passed in IN number 2 of 2023, passed by the Honorable District Court West Yangalo shall not be set aside, and on cause or causes shown and after hearing the parties be pleased to set aside the impugn ex parte order so and so. Your lordship. And in the interim, your lordship, during pendency of the case, be further pleased to stay operation of the impugn ex parte order dated 9/10/2023.
The operation of the impugned ex parte order is stayed until further orders. You call for the case records,
Case records, scan copy of the case record.
call for the scan copies of the case records. List the matter of litigation.
Yes, your lordship. Deeply.
May I please, madam? This is a joint petition filed by husband and wife to quash a criminal case lodged against husband. The FIR was lodged by wife against the husband for having an extramarital affairs with some.
So
Yeah.
this petition number 1 is the husband,
Yes, one is
Okay.
husband and two is wife.
and 2 is wife.
Now, after investigation, this case has been charged against husband, which is,
Pending at which stage?
my lord,
This case is pending at which stage?
section
Huh?
498.
Pending stage of pendency, trial or charge sheet or charge sheet you have said it's submitted.
It's on CC on next day. That is on
Or
this,
charge
yes,
consideration.
17.
Where is the charge sheet? Under which sections he has been charged sheeted?
My lord, charge sheet is in page 21.
He's been charge sheeted under sections.
And when we kindly come to page 21, this is the operating position. It's under 498A 506 323 IPC. Except
Page 21,
29,
29.
yes. Last paragraph, under primary case under.
Lordship, may I lordship? Lordship, this application, this lordship petition is not maintainable, lordship, because this is filed under joint petition. But there's no joint this affidavit as such, lordship, had been annexed, lordship here. And lordship, here, lordship, they have annexed on KEBA decision only. So KEBA decision cannot be a lordship ground for the lordship settlement lordship, because settlement between the two parties should be lordship clearly lordship in affidavit form between the joint petition lordship, because they have come for the joint petition under joint petition. So, lordship,
No, my lord, here, joint, we have filed affidavit also. We are coming here jointly itself indicate that we have settled the matter.
Where is the affidavit? That with the affidavit supporting the petition?
Yes, two affidavits have been filed separately by husband and wife.
Where?
It's in page 13 is the affidavit of husband and 15 is the affidavit of wife. This affidavit is supporting the petition.
file
Lordship, they should have come like lordship with the proper lordship settlement agreement, lordship. And lordship, they have lordship here, lordship in their petition also, they have made party the officer in charge also as a respondent.
we can represent him.
Lordship, I think lordship, they should lordship amend the petition lordship, and they have enact the proper lordship settlement agreement between the parties lordship. Because this is
For-
under 482 lordship, yes, lordship,
For future, maybe.
lordship, because this
In
is
case any dispute arises.
lordship, because this is KEBA decision lordship, this is, they have annexed the KEBA decision. And lordship, as per this KEBA decision lordship, they had this other page, lordship, last page, the Srimati, this the complaint shall withdraw the case filed by this lordship. And lordship, and here lordship, that accused has not attended that KEBA also lordship. So this is ex parte decision also lordship.
No, it's false. They have wife has called Kavan to village authority as per regulation. So on first occasion, I objected. On second, I appear and
323, I think 506. Husband and wife, maybe.
It's understood lordship, under there, I have no problem if there is proper lordship, agreement is there lordship. Lordship, this matter
So
was
there
come
won't
up,
be any risk factor if they file an application.
lordship, and this matter was come up on 29 also
you
lordship.
know, matter speaks on 1710 for this CC. So if this is, I'm ready to file a joint affidavit if necessary, but it's in 482, it's not mandatory. Only
Not
Yes,
required,
not
but
required.
just for the risk factor is still there always.
But
Because the
in the meantime, this next
allegation is there.
yes. Next proceeding may be stay. I'll file on next.
And
She's
lordship,
right, I was thinking of disposing it, but
Yeah.
she's right.
lordship, even I had
There
no
is
problem
still a
lordship
risk
when,
factor.
if there was lordship, proper lordship settlement agreement was there lordship. And lordship, on the page 48 also, the last date was
That
when
KEBA
the
decision is more against the woman than the man. Ordering her to withdraw the complaint.
No, but they are both the parties has agree the matter. If we come here jointly, then it's still suggests that we have settled the matter.
Okay, we will stay then.
Yes.
We will
it-
stay.
lordship, here lordship, on the last occasion lordship, there's 29-23 lordship. This matter was fixed for the appearance of the accused. The accused was affair lordship. No, accused was not affair, or accused was affair, but they did not apprise the court about this settlement lordship. And that KEBA decision was passed on 23/5 lordship, and this last order was passed, this court was seated on 29/23.
Okay, we will stay the proceedings
Yes.
and then. you
In the
can
meantime,
file an
I'll file.
affidavit.
Yes.
So the risk factor will be done away with.
Lordship, in the meantime, they also filed lordship, this IA with the lordship document lordship.
Yeah, nowadays you'll have to file with the IA, I believe,
Lordship.
anything, whatever you want.
Lordship. And scan copy of the LCR may be called.
Scan. You want to scan copies of the LCR also?
Lordship, because the stay
Only
is
for
granted,
SARS,
lordship,
huh?
stay is
Only for
granted.
CC. Okay, we'll forward the scan copies of the LCR. Item number 17, heard Mr.
K. Dabi.
K. Dabi,
Yes.
learned counsel for the petitioners. The petitioners number 1 and 2 are spouses. And they have filed this application under section 482 CRPC. With prayer seeking quashing of the entire proceeding,
Yes, enter proceeding.
quashing of the proceeding of which case? GR case.
Yes. Women PS case number. Allow women PS case number 4/23.
Quashing the FIR of ALO
Yes.
FIR. That is the ALO women PS case number 4/23. Registered under section 498A 506 323 IPC as well as the charge sheet number 02/23 dated 3/7/23. Heard Miss L. Hage, learned edition PP, Arunachal Pradesh. As the petition, have considered the submissions on behalf of the petitioners. The petitioners have made out a case for interim order. The further proceedings of GR case or
G-
PRC case.
GR number 24 of
GR case number 24/23 pending in the court of the so and so.
CJ
They
Malo.
stayed until the returnable date. Till the next date of listing. Call for the scan copies of the LCR. Notice is not required to OC. You will represent him.
In the method proceeding.
Lordship,
I have stayed the proceeding.
Lordship, proper lordship, affidavit lordship, the settlement agreement should
The
be.
petitioner has submitted that he will file an agreement, affidavit or agreement. He'll file an agreement.
Settlement agreement, lordship.
He'll file a deed of agreement on the next piece, which is allowed
Apply.
after vacation.
Yeah, Madam. Madam, the present applicant is the father of the alleged accused person who is presently under judicial custody at Alok. In this petition, Madam, I am praying for modification of the two conditions imposed by this honorable court in order dated 21/9/2023. This court, Madam. By that order, Madam, the alleged accused person was granted bail. However, two conditions were imposed. That order, Madam, will find at page number 10. Relevant portion, page number 11, last paragraph. Also. Accordingly, the accused named above shall be released on bail in connection with Alo PS case number 31/2023 registered under sections 409/34 IPC on furnishing bail bond of ₹50,000 and two suitable sureties of like amount, out of which one of the sureties should be a government employee.
Why? What is the wrong here?
My lord, the present applicant is a daily wage earner.
Daily wage,
Daily wage earner.
daily related wages.
He is a beneficiary of AYY ration card. That ration card, my lord, I have annexed at page number 9.
Please read the order, bail order.
Accordingly, the accused name above shall be released on bail in connection with Alo PS case number 31/2023.
Just a moment,
Sorry.
I'll read the bail order. Money has been transferred to your account? How much money?
My lord, in this petition, my lord, I'm not going with the merits, my lord. I'm just praying for modification.
No, I
of
must
the-
know the merits to modify the petition.
Sorry,
I must know the merits to modify the petition.
allegation, my lord, is that some amount was
What is the
transferred in
amount? What is the amount?
amount that's around what I have been told, it's around 1 lakh,
One.
1 lakh. By the main accused, he's still at large. After that, the amount was transferred further to the main accused, account of the main accused by the present alleged accused person.
Yes.
My lord, for a moment may come to page number 9, that is the ration card. Ration card has been issued in the name of the wife, my lord, applicant's wife. This is a AYY/PHH ration card, madam. PHS ration card, madam, was previously known as BPL ration card. A person who lives below poverty line, madam, it's
Yes.
impossible for him to arrange 50,000. And, my lord, the second condition also, Mr. Government employee, given the modest background he's from, he has no government employees in his family. Neither he knows any government employee in state. of
Understand.
Since your lordship, this matter has taken up by the bail was granted by the Justice Malis Green on the bench. And modifications
Has to be
maybe
done by
has
that
to be
bench.
done by our bench.
But
If she is not available in next few days, then VC can be kept, then in these days, we are
So should
using
I-
VC.
The advice for receive the matter before the appropriate bench to VC it can be done.
Yes.
No, there's no law which says that this cannot be taken up by a coordinate bench. If he's able to show the law. I
It's
quite-
all about judicial propriety, your lordship. It's not all about the law.
Only because of the two conditions, my lord, a person's fundamental right under Article 21 is being violated. If these conditions are not
I'm-
modified, my lord, he will languish in jail forever now.
Moreover, your lordship's learned petitioner has adduced one reciprocal document which is written in Assamese script, so I cannot read or write Assamese.
Earlier we used to modify, but now that the VC has come,
Yes,
so earlier we used to.
it's,
modify
yes,
Because the VC was not available, so we used to modify somebody else's order also, some other bench's order also, I have modified earlier. But now that the VC is available, so I don't know,
we usually,
we should offer the procedure, proper procedure. Through the VC,
Tomorrow, my lord, otherwise.
yes,
obviously,
this is the matter, tomorrow we could have put it.
All right.
Tomorrow direct to read, but tomorrow will be direct to read.
My lord, this criminal petition has been filed for quashing of the proceeding in the court. My lord, the allegation is serious, but the MLC report shows that no offense has been committed. And in the meantime, the matter has been settled.
Under which was charge sheeted under section 376(2) IPC, read with section 6 of POCSO Act. Lordship, here the rest, both the petitioner, it's a joint petition, both the petitioner were in a relationship, consensual relation, out of which they had a daughter. After the birth of the daughter, the parents of the petitioner number 1, on the assumption that she is a minor, pressured her to file an FIR, register an FIR. The FIR is at page number 19.
So we'll call for the LCR.
Is the
No,
POCSO,
stay, no.
your lordship, POCSO Act,
Yes.
POCSO Act has been dropped.
Dropped,
Yes, the order,
charge sheet has been.
charge sheet in the CC stage, it was dropped, POCSO.
During the CC stage. it was
Yes,
dropped.
because
Let me
after
see the CC order, charge sheet order.
page number, your
Framing of
lordship,
charge,
38. Page number 38. Fourth paragraph.
yes,
And after
376.
it was, she was declared as a major. Now they are in consent, their relationship, and now they are happily married as husband and wife and have a 4-year-old daughter also.
Yes. Only you have an interim state,
yes, LCR is required in this case, LCR is required.
LCR.
And
Just praying for interim state.
interim stay, it may not be granted at this, because your lordship may peruse the agreement, settlement agreement they arrive into, that is page 42. And thereafter, last page, it is page 44. Only both parties have signed it without any witnesses available.
There no need, your lordship, they are both are major.
Now, big question arises here also, there the authenticity of the signature.
No, witnesses are required.
Witness must be there. Either of the parent or relatives
And-
or friends.
Lordship, in the
At
state,
least the informant. No, she is the informant.
she is the informant. And I have annexed the medical records of the daughter also. There clearly it is the daughter of the petitioner number 2. And she is now 4-year-old and he is taking care of the petitioner number one and the
Can we
daughter.
state, I think?
And there are. serious
Your Lordship,
categorical judgment.
statement of 161 is there. But as per the charge sheet, statement of victim and both accused under 164 was also recorded. And here in the allegation on FIR, victim herein clearly alleged the accused that she was driven out of the house without allowing her to stay at home. And in the presence of accused, victims' relatives also. Because all victims' relatives know came to this fact. And here accused admitted that he had
You have the LCA?
no, as per his record. So that's why LCR is required without staying the proceeding. Because tomorrow if really LCR comes in his favor, that he will, this court will
You
be,
can drive her out.
yes. So we need to check the LCR.
Stay, otherwise your lordship on the next day,
Next day okay, next day we'll discuss about the stay.
your lordship.
You
it
Place a
will
submission
already-
regarding the stay next date.
Lordship, I have categorical judgment which says that if the both parties are married and they already have a daughter and they are living together, this matter can be quashed. There's a possibility that it can be quashed.
But your, I think your situation is different. Here, he has already driven her out.
No, lordship, that submission was made prior, considering she was a POXO at that time. And the family pressured by the family there. Now they are living together and he is taking care of both the.
So we will go through the records. We will go through the records. And then we will, then you give a agreement which is more valid with supported by witnesses' signatures. All right.
This is other lordship, it's on next day, there's evidence, otherwise it will be.
Then-
Evidence, this is not a
The more
conclusion
the
of
better.
trial. It's not a
So she will
conclusion of
not
trial.
implicate him.
Here, accused wife and daughter also involved to driving her out. Accused earlier wife.
Okay.
This is the.
This is the case. That's why LCR is
Okay.
required and no interim may be
Get
granted.
get the statements of the witnesses and then we will consider the matter of stay. So she is the second wife.
Yes.
Yes, deemed to be second.
Third learned counsel for the petitioner, Mr.
Yes.
And
G.
learned additional PP for
Ji Tata.
petitioners, joint
Petitioners,
petition,
joint petition.
petitioner. And Mr. G. Talu,
Yes.
learned additional PP, Arunachal Pradesh. Call for the scanned copies of the LCR, the the matter of stay, interim stay will be considered after receipt of the
LCR.
LCR. Call for the scanned copies.
Yes.
No?
Obviously.
This is the matter of the puja vacation.
Obliged.
Yes, I mean. I am my lord, agreed by my lord, order dated 13/12, sorry, my lord, yes, 12/7/2023, my lord, pass in CR, my lord, case number. So, sorry, my lord. Their case number 25/2023, my lord, by the learned JMFC UPM, my lord. Before coming to this complaint, my lord, what happened in this case, my lord, petitioner number 1, my lord, is assistant engineer, my lord, public servant, serving under PWD department, my lord. And petitioner 2, my lord, is chief engineer, my lord, of the same department, my lord. 3 is superintendent engineer, 4 is, my lord, executive engineer, my lord. 5, my lord, is a private party, my lord, PAM, my lord, executing the work, my lord. What executing the work, my lord? What happened, my lord? State of Arunachal Pradesh, my lord, sanction a work, my lord. The name of the road is construction of work, my lord, from BTRA road to Taji Langpo at Kamba village, my lord. A road was sanctioned, my lord. According this petition, my lord, 1 to 4, my lord, being a public servant, my lord, department, started the construction work, my lord. Now, this private respondent, what they did, my lord, they start to complain, my lord. First day, my lord, before this complaint, my lord, they file a FIR, my lord, saying that, my lord, in the tender process, there are some forgery committed, my lord. That FIR, my lord, culminated into final report, my lord. Now, thereafter, my lord, they again approached to SIC, my lord. That also culminated into FIR, my lord. They challenged it before the session court, my lord. Both the proceeding, my lord, withdraw, my lord. Thereafter, this complaint, my lord, alleging, my lord, violation, my lord. Their prayer, my lord, they are now praying, my lord, punishment of the respondent under, my lord, the section 19C of Environmental Protection Act. Read with and, my lord, section 30A of Forest Act, Forest Conservation Act 1980, my lord.
Who is the FIR?
No FIR, my lord, private complaint, my lord.
Private complaint, who is the complaint?
Private complaint, my lord. I will just indicate the relevant part only, my lord. My lord will kindly turn to page their complaint, my lord. Start from, my lord. 59, my lord. '59, my lord. And relevant part only I read, my lord. Page number 59, my lord. Their complaint filed under section 19B of Environmental Protection Act 1986, read with section 192 200 CRPC 1973 for offense committed under section 15 of Environmental Act 1986, read with section 3A of Forest Conservation Act 1980, my lord. Now, my lord, know that, my lord, this is a special act, my lord. There is a special provision, my lord. In terms of the section Forest Conservation Act, my lord, private complaint would not maintain, that is sure, my lord. Now, in terms of section 15 of Environmental Act, my lord, there is a specific procedure, my lord, how complaint is lost, my lord. Now, that mandatory provision, my lord, has been not followed in this case, my lord. I will come to that, my lord. This to on about, my lord, Forest Act, my lord, Conservation Act, my lord. There is no provision, my lord, under the law where private complaint is lost, my lord. It is clear, my lord, under Forest Act, my lord. Only authorized person, my lord, by the central government that can lose a FIR, my lord.
You see the Forest Act?
Forest Act, my lord. That is clear. Forest Act, my lord. In terms of Forest Conservation Act 1980, my lord, a Forest Conservation Rule 293 is being framed, my lord. Rule 3.
Let him get the books.
Rule in the rule, my lord, Forest Conservation Rule 230 and Rule 9 will be relevant, my lord. Where
You get the books. And Environment Protection Act also. Forest Conservation Act and Environment Protection Act.
This is, my lord, new one, my lord. In new one, my lord, this rule is issued, my lord, but I mean, some notification is there, my lord. It is the rule, my lord, applicable, my lord. Now, this rule, 2000 rule, my lord, has been done away with, my lord, this Forest Conservation Rule 2022, my lord. Now, Rule 22, my lord, yes, my lord, this rule has been somehow missed by the government, my lord. That's why, my lord, this notification come, my lord, and this is the notification, my lord. Here also, this is clear, my lord. This case. If, my lord,
2000?
my lord, this rule, my lord.
Rule
Earlier, my
2000?
lord, this Forest Rule 2003, my lord, was there, my lord.
Forest Conservation Rule.
Rule, my lord, 2003.
2003.
Now, this has been
And
done
this
away.
rule- This rule is, which
This
has
rule
been done away in the new rule.
by 2022, my lord. For same, my lord, Forest Conservation Rule 2022, my lord. Now, in this rule,
Which rule? 2.
3, my lord, Rule 3, my lord. Forest Conservation Rule, my lord, has been done away with this Forest Conservation Rule 2022, my lord. In this, my lord, rule, this 9, my lord, rule has been missed out, my lord. That's why this notification has been issued, my lord. I have placed that, my lord. If,
15 May 2023, and your offense was prior to 15 May 2023.
Please, my case will pose under this rule 293, my lord. Rule 293, my lord, 9, my lord, it's married, my lord, it's same, my lord.
Rule
This
2003, 3.
rule, my lord. 293,
Rule
my lord.
3. It is there.
Dear, my lord. Then in rule 9, my lord. In the rule 9, my lord.
Yes.
Rule 9 say, my lord, the central government may by notification authorize any officer not below the rank of conservation of police or forest or the concerned forest officer having territorial jurisdiction over the forest land in respect of which the said offense is to have been committed to file complaint against the person prima facie found guilty of offense under the act or the violation of the rule under therein in the court having jurisdiction in the matter. Provided
They are
that
private persons.
they are
cannot
private,
violate.
this cannot maintainable, my lord.
Yes.
In term of my lord, Punjab, this
And regarding environment,
environment, my lord, yes, my lord, there is a one provision, my lord, provision is there, my lord. But that provision, my lord, my lord will kindly turn to my lord, section, my lord. 19, my lord, how come this is taken in this case, my lord?
section 90.
19, my lord. 19, my lord. One nine, my lord.
Yes, yes.
It's a my lord, sub clause A, my lord, it's a my condition opens, no court says the condition any opens under this act except on complaint made by
All right, all right.
the central government.
All right. Yes.
At B, my lord, there is a provision for a private party also, my lord. That is, but there is that it
Okay,
need,
there is a provision for private party.
yes, my lord. B, my lord, dear. B, my lord, any person who have given notice of not less than 60 days in manner prescribed, my lord. That is important, my lord. In manner prescribed, my lord, of the alleged offense and of this intention to make a complaint to the central government or the authority.
So you have to give notice for 60 days.
Yes, ma'am. Notice now prescribed. They have also enclosed, I have enclosed their notice also. Notice, the notice need to be under, my lord will kindly form 6, my lord. In my case, it is 169, my lord. Form
Form?
4, my lord.
Hmm?
Form number 4, my lord.
We'll get it in the rules, no?
Rule, my lord. Schedule, my lord, in
Schedule.
schedule, my lord.
Which schedule? 1?
Schedule DS 1, my lord.
Form 4, schedule 1.
Yes, my lord. As much as 5 form is prescribed, my lord. Appendix A.
Pass me a book.
Down below, my lord. Form number 4, my lord. No, my lord. Form,
This is schedule 7.
oh, sorry, my lord.
Form 4. Okay.
My lord. There is a mandate, my lord. Now, in there, my lord, if my lord see that they need to, my
I'll
lord.
check the form in my. I got it now.
No, my lord.
It's under schedule 7.
Yes, sir. It's schedule 7, my lord. See,
I was searching under schedule 1.
Yes, my lord.
All right.
If my lord, we kindly look into my lord, for my lord, at last sentence, my lord, for violation of my lord section, my lord. We hereby give notice, 60-day notice and section 19B of Environment Act of my intention to file a complaint in a court against my lord for violation of section, my lord. Now, section need to be specific, my lord, if this is necessary, my lord. One person cannot say, my lord, I want to punish you under IPC, my lord. It should be, my lord, I want to punish you under section either 107, 102, my lord, 202 or 302, my lord. That is this is a
Of the
prescribed.
Environment Protection Act.
Yeah. Now here what they did, my lord, if their prescribed notice, my lord, we by net page number, my lord, 75, my lord.
So now I will issue notice to them.
Issue notice, my lord.
I'll
In the
issue
meantime, my
notice.
lord, further proceeding we need to be still, my lord. This is
Right,
totally, my lord. Pardon,
What kind of proceeding?
this criminal proceeding, my lord. They now on the basis of this, my lord, this process has been issued, my lord, by the learned court below, my lord.
Proceeding is pending at which stage?
For appearance, my lord, one person appear, my lord, are need to be appearance, my lord.
No. No. We'll issue notice and we'll hear the other side.
No, my lord. My lord.
Yes, you have a point.
No, my lord, that
You
if
are right, you are very correct. You have a point.
my lord, when I'm playing East, my lord. If my lord on
They are not arrested. Are they arrested?
no, my lord, this is private complaint, my lord. There cannot be arrest, my lord. This is a private complaint, my lord. Now on the page of record, my manifestly, my lord, this is my lord. I have
Only I'm asking for only one date. Give me only one date.
no, my lord,
What
in the next day, my lord, where I'm pressing, my lord, in next date of the case is fees on 30, my lord. I would say, my lord, still returnable date, my lord, my lord, my lord. Otherwise, my lord, my lord,
Returnable day, I know what is still.
it is
returnable.
not a
It will
case.
Go on and on.
No, my lord, it is not a case of private person, my lord. It is a case of public servant, my lord, discharging their duty, my lord. My lord, on the record, if my lord turn to impugn order also, my lord, my page 192, my lord. It is not, all the fake, my lord, necessary fake was before the landed court below, my lord. 192, my lord.
I'm asking for only one date.
My lord,
Only one date.
no, my lord, one date, in the one date, my lord, next day, 30, my lord. 30 of this.
One date, I want to hear the other side.
No, my lord, why, my lord, if my
But
lord,
they are wrong. They are wrong.
my lord may kindly appreciate, my lord. My lord will kindly have a look at the impugn order, my lord.
Now, this complaint, according to you, whatever you have shown me,
My lord,
this complaint is not proper.
my lord.
But
Ma-
I want to
eh,
hear them.
In addition to that, my lord, this is totally vindictive, my lord. Now,
Then I'll go, which page are you suggesting? 190?
192, my lord, kindly, my lord, 192, my lord. And all that is fake, my lord, before the learned court below, my lord, 192, my lord, one annexation number 11, my lord. This is the one of impugn order, my lord. Instance complaint, my lord, may I read, my lord, this, my lord. Complaint are represented landed the hard council on the point of prohibition sanction to prohibit the 80% and they are all government servant. Instead, complaint filed under section 4B of the Environmental Protection Act 1986, read to section 200 against 80%, chief engineer central zone, the superintendent engineer zone, the executive engineer, my lord, the assistant engineer, my lord. Now, my lord will assume the situation, my lord. It is not a case, my lord. It is not a case of corruption, my lord. They are trying to, my lord, malefiantly, my lord, with a vindictive, my lord, try to prosecute a person, my lord, for discharging their official duty, my lord. Ultimately, if I allow to go into whole report, my lord, I will show, my lord, this all, my lord, work, my lord, has been done under discharging their official duty, my lord. Now, for discharging official duty, for discharging public duty, my lord, if person is allowed to face trial, my lord, that is surely, my lord.
He has relied on the decision of the Supreme Court. Have you
No, no, this is not of Supreme Court. This is,
Plant Delhi versus State of Maharashtra.
it is about my lord, prosecution sanction, my lord. I am not pleaded, what is my landed council complaint, submit EAP is a special act. It override a provision of CRP. So for proceeding for filing a complaint under section 19 of the Act shall applicable, no prosecution sanction under 190 is required for prosecuting. I am not on the
Next page,
next.
next page, you read the.
Yes,
next
madam.
page.
Is required for the government official under Act. He has placed what it is about prosecution sanction, my lord.
Let me see this judgment at least of the Supreme Court.
No, my lord, this is
Tomorrow-
total SCC online Bombay High Court, my lord. Bombay, my lord.
Bombay High Court also.
No,
Bombay High Court may rely on
no,
judgment.
no, that's why, my lord, I am not pressing this in term about
No,
the
I will have to go for this judgment.
no,
He has relied on this judgment.
only one sentence, my lord. My lord, kindly appreciate, my lord. I also
Tomorrow then you bring this judgment tomorrow. Tomorrow.
this judgment, my lord. This judgment is it favor my case, my lord. Though I
Very well and good then.
Yeah, madam.
Stay.
tomorrow they let
Judgment tomorrow.
me.
Yes.
Tomorrow,
If you can produce it in the afternoon after 2. After 2,
today, my lord.
yes.
Yes,
Yes, after 2.
overlessment.
And we have 5 more minutes. Let me go through the petition.
Yes.
Complaint petition.
Overlessment.
Read out the complaint petition, which page?
Complaint, my lord. Complaint also 59, my lord. Here also, my lord,
Page 59.
59, start from 59, my lord. If my lord, see, my lord, this is totally in the complaint, from the face of record, the complaint also, my lord, will find this is a vindictive, my lord. What they, my lord? On the one hand, my lord, if I am skipping other aspect of the, my lord will kindly see it far 8, my lord, of the complaint. That is at page number 67, my lord, 67. This is part of complaint, my lord. 8, my lord. 8, my lord. The complainant dated 2/7/2022 was also submitted to 1 Sri, such and such before the
Page
accused.
8. Page 8.
Pardon, my lord.
Which page you are reading?
67, my lord. 67.
67. Page 9.
Yes, my
9 of
lord.
the complaint, okay.
The complainant represented letter dated 2/7/2022 was also submitted to 1 Sri, such and such before the accused. 1, 2, 3, seeking stoppage of further continuation of above road construction work till environment forest clearance obtained from the competent authority by making lane compensation to the affected person with according to law, my lord. Basically, my lord, they are trying to, my lord, say that, my lord, we need to be compensated, my lord. And for a moment, my lord, kindly, my lord, dear, my lord, statement on oath, my lord, page
Para
number
9, para 9.
Para 9 also, my lord. Para 9 also, my lord. The FIR dated was also lost before that. This is, my lord, FIR police station alleging that the huge mean for bridge construction from Peter Road to Tambarampo and Sangram was misappropriate, compromising the quality of road by preparing faked in the record by engaging prudent in the expense and efficient contractor, my lord. Now, that's why I'm saying this is totally vindictive, my lord. It was also alleged a rampant violation of environmental law in construction roads, since there is no period forest and environmental clearance. No step is taken against any person, my lord. Now, my lord,
Let me go to para 7.
Para 7, my lord. That, my lord. That after this is the basic allegation in their case, my lord. Para 7. That after entering the agreement dated 11/1/2019, my lord, this tender agreement, my lord, the accused start diverting the forest lane of the complainant, my lord. My lord, it kindly to also with this, my lord. On the one hand, my lord, they are lodging a complaint under Forest Act, my lord. And on the other hand, they are saying that these are their land, my lord. In other in construction, the above road from non-forest purpose illegally and in complete violation of law and prescribed under environmental impact assessment not being to issue under sub rule 3 of the rule 5 of environmental protection rule 1986 and the forest conservation rule 2004. In fact, the forest lane was diverted without obtaining prior environmental clearance, and prior forest clearance was required under EI notification 2006. Now, my lord will kindly note EI notification 2006. What is EI? I have also annexed it also, my lord.
If my lord CEI notification to my lord, I have annexed it as a annexure number, my lord. 13, my lord. 13, my lord. Where my lord, when my lord, this clearance is required. If my lord kindly turn to page number
Page 30,
214, my lord, 214. 214, my lord.
214.
My lord.
Yes.
This is a schedule, my lord, where this clearance is required. my lord.
No, sir, I just wanted a little accommodation. If my matter can be taken at 2 o'clock, I would look for admission.
You come from Guwahati. So you're planning to return back today itself?
Yes, I have some members fixed tomorrow.
Okay, okay. We'll take up at 2 and then after we hear you.
My lord.
Obliged.
My lord, for the moment, 214, my lord, please. In case of highway, my lord, construction road, where my lord clearance, environment clearance is required. Environment clearance is required in column number 3, my lord, national highway and all state highway, my lord. Whereas this is my lord, district.
Column number?
My lord to 7F, my lord. My lord,
7 and
row number, row second, my lord, 7F, my lord.
7 airports.
7F, my lord. Highway, my lord. The clearance of environmental, my lord, is required only in case of national highway and state highway, my lord.
This is not national highway or state highway.
Pardon, my lord.
This road, huh?
In our case, my lord, it is all district highway, my lord, or district road, my lord, village road, my lord. There is no question of my lord obtaining
What road?
village road, my lord, district road, my lord, district road,
District road.
my lord. In such case, there is no question of obtaining any environmental clearance. my lord.
That I don't know.
No, that's why I annex this, my lord. This is the notification, my lord. If my lord say highway, my lord, where it is required, my lord, national highway, all state highway, my lord, state highway expansion project, hilly train, and my lord. Only in those cases, my lord, that is required, my lord.
Right.
Oh, I place this judgment, my lord. This is about the position section, my lord, favoring my case, my lord.
All right, then better,
Yeah.
well and good. Good
Oh,
for you.
bless.
Case number 12 of 2003. It's a money execution case. Lordship, what had happened, an ex parte decree was passed against me. So thereafter, I had no notice of that. Lordship, but remember, it was during the COVID time. The entire proceedings of the case was during COVID time. COVID time, Lordship, really no one knew. They couldn't get the wits around them. Everyone was under the fear psychosis. So anyway, we didn't get the notice, whatever reasons. Notice was not given. Then court had asked the plaintiff to give a newspaper notification in 2 national dailies. Unfortunately, again, I would blame it to COVID, so things were not working. He filed in local dailies. That was a departure from what the court had directed. But be it as it may, we did not see the newspaper notice. Order was passed against us. Thereafter, when the execution was initiated, I got a notice of the execution. And the first time I got to know that this kind of suit had been filed against me. On the merits of the case, Lordship, I will not go to take your Lordship to that right now, because even if Lordship looks at the money suit and the decree which was passed, ex facie, prima facie, Lordship, it's absurd. Because briefly, it was barred by limitation, and it was filed against a dead person, and decree was granted. If I may say so, even the decree is not an executable decree, because though money suit has been passed, the amount has not been apportioned, nor has the money suit been filed jointly and severally liable, even not. Defendants are liable to pay very vague. And we would find that even strangers to the suit, money which was transacted between the plaintiff and that was also formed a part of it. All these things are there, Lordship, that's a part of it. But the point is here, I did not get any notice. Now I have come and I have placed before the court below. Let's see, this is the position which I didn't get notice, I couldn't come. And it is only proper that this is vacated. I may be given a chance to contest the suit. But of course, the learned court below did not accept my contentions. If Lordship would come to page 15, which is the impugned order passed in the execution in Miss Case 12 of 2023.
Page 15.
Yes, I'll take Lordship straight away to page 615, where he says that these are the grounds. Lordship will find the points which have been enumerated here. It's pleaded that the service of summons as per Order 5, Rule 21, and publication of notices in newspaper under Order 5, Rule 21 is not tenable in law as the applicant is still unaware of which issue the advertisement was published and contended that the applicant neither read nor subscribed to the newspaper where it was published. It's further contended that had applicant received the notice, though which it was caused, the applicant would have challenged the suit hotly inter alia on the following points. They say the points on which I would have challenged. But the point is, I did not get notice and I did not come. And I say I did not read. Court did not accept these contentions of mine. Simply did not accept. Court also did not look into the veracity of the decree. I mean, even while Lordship sets aside an ex parte order, or Lordship will not set aside the ex parte order for the sake of setting aside the ex parte order, even if I have a good reasons, because would it further the cause of justice? That is something Lordship would always consider. I mean, I have always found that whether setting aside would further the cause of justice or would it be an exercise in futility? This is something to be, because after all, we are talking about judicial time also. So these are the things which have been has to be taken into consideration. But the instant case is a case which is different, where if had one look at the judgment, one would have found that yes, there are flaws. Whether the judgment is executable, I have my serious doubts. So in that case, this execution case would just go on from here and there, High Court, Supreme Court, etc. Now, purpose really would be served. So better purpose would have been served to set it aside, give me a hearing, because as I said earlier, if I just take your Lordship to the judgment of the court below, then I'll just take the last part. I don't have to take the Lordship to anything else. This is the last part where he passes the decree order. That's at page 45, page 67, internal page 45, page 67, which is, this is the order. In view of the discussions made in the aforementioned paragraphs and decisions reached therein, the present suit is decided in favor of the plaintiff. The plaintiff is entitled to recover rupees this much, 1 crore, etc., only from the defendant, along with interest at the rate of 16% per annum. Now, this amount is not apportioned. If I am another person, defendant number 1 who was there, it's a totally, and actually defendant number 1 died even before the suit was filed. So this suit actually had abated. And a suit against a dead person is not maintainable, and no decree is maintainable on that. So defendant number 1 had died, the main defendant, he had died. And now this is a decree which has been passed. Now can this decree be executed? It's not jointly and severally. Decree, money has not been apportioned, nothing. It just decreed. I mean, this one can, if one looks at the order sheet, during COVID period, when there were a lot of SOPs issued by the government, the central government, state government, even the High Court, the emphasis was only to take measures up for the courts to take up matters of extreme urgency. And that is what was followed. I mean, even to get a case listed, I mean, one had to satisfy the registrar that it is of extreme urgency because the situation demanded that. The pandemic demanded that. Now, this money suit is not a money suit of such extreme urgency that should have been gone on during the COVID period. Anytime there's a break, there's a date, and that's what happens in the order sheet. But I'll not go into that. I'm not on the merits of the thing. I am only on the ex parte order. So my respectful submission before your lordship that this records may be called for, and the execution the proceedings of the miss case number 2 of execution case number 5 of 223 be stayed pending. Short date, lordship. I'm not asking for a long date. Let us
Execution, this case number 12 of 22.
execution, yes, miss case number 12 of 23 in money suit number 39. Very short date. Lordship, I'm praying for let the records be called from. It's from Alo, it will come. The matter can be stretched out. I mean, even I don't want to prolong this.
I'll just want to clarify some points. This money suit, original money suit,
Where?
that was not heard ex parte.
That was ex parte.
That was ex parte. And the miss case,
Mixed case is not ex parte.
not ex parte.
Not ex parte. It was represented throughout.
Yes, what do you have to
Miss
say?
case has been filed by them now.
Yeah,
Itself.
that happened.
Miss case has been filed by them under Order 9 Rule 30, my lord.
Order 9.
Order 9 Rule 30. So that has been rejected by the learned court below. And against that, they have filed this RFA. Before going to the contention of the notice, as my senior advocate has mentioned it, I'd like to point out one thing, your lordships. They have filed this RFA, regular first appeal under Order 41, Rule 1 and 2. This is not maintainable. Why this is not maintainable? When an application under Order 9 Rule 13 has been rejected, there is a specific provision under Order 43 Rule 1D. Your lordship will look at Order 43 Rule 1D.
Order 43,
Rule 1D. Lordship got it?
yes.
May, my lord.
Yes.
May I read, my lord? An appeal shall lie from the following orders under provisions of section 104, namely, I'm directly coming to D, my lord. An order under Rule 13 of Order 9 rejecting an application for an order to set aside a decree passed ex parte. There is a specific provision. They have to file under Order 43 Rule 1D if they are challenging this petition. And if they are challenging the judgment and decree dated, which was passed in the year 2021 under Order 41 Rule 1D, then it will be RFA. But under 43 1D, the nomenclature, it must be registered under FAO, my lord. First appeal against order.
I agree, lordship. It has to be Order 41.
And if they file under Order 41 Rule 1D, then they must have filed a petition for condemnation of delay. Because first court has to condone the delay, then the court may stay the proceeding. Because what is stated in under 41 Rule 1D, lordship may kindly have a look.
Yes, which order?
Under Order 41 Rule 1D, which Order 41 1-2, Rule 1-2. And I'm directly coming to rule 3A, my lord. Rule 3A, 41, rule 3A.
Yes.
Application for condonation of delay. Subrule 3, my lord. I'm reading from the subrule 1 itself. When an appeal is presented after the expiry of the period of limitation,
Your reading order?
order 41, rule 3A, my lord.
Am I reading 41 right?
My lord.
I'm just checking, am I reading 41 right? Order 41, no?
Yes.
Order 41, rule 3A.
3A, my lord.
That is the rejection or amendment of memorandum.
No, order 41 or appeals from original decrees. Then rule 3A, my lord. Not
Yes.
3,
Yes.
3A.
Yes, sir. Yes, all right.
Application for condonation of delay.
I can't get.
When an appeal is presented after the expiry of the period of limitation specified therefore, it shall be accompanied by an application supported by affidavit setting forth the facts on which the appellant relies to satisfy the court that he had sufficient cause for not preferring the appeal within such period. Next, if the court sees no reason to reject the application without the issue of a notice to the respondent, notice thereof shall be issued to the respondent and the matter shall be finally decided by the court before it proceeds to deal with the appeal under rule 11 or rule 13 as the case may be. Next, my lord, where an application has been made under rule 3, subrule 1, the court shall not make an order for the stay of execution of the decree against which the appeal is proposed to be filed so long as the court does not, after hearing under rule 11, decide to hear the appeal, my lord. So if they are filing under order 41, rule 1 and 2, then court has to first condone the delay, then court may stay the proceedings.
There's no delay. There's no delay.
Why it is delay? Because if they are filing under 41, rule 1, 2, then they have to challenge the decree original order, and which have been here, they have filed the application under 41, 1, 2. Means in their prayer, they're asking for setting aside both. If your lordship will look in their prayer at page 9,
Page 9.
page 9, my lord, in their RFA.
Yes.
The prayer portion, my lord. In the premises of it is most respectfully prayed that this honorable court would be graciously pleased to admit its regular first appeal, call for the records, issue notice calling out for the respondents, defendants to so cause as to why the impugn order dated 36 to this should be 2023, pass in Miss case number 12 of 2023, as well as expertise judgment and decree dated 22/10/2021, passed in Manishut number so and so. They're challenging this also and they're challenging that also. So the whole petition is baseless. Therefore, my humble submission before lordship to dismiss this appeal itself, number 1. And now I'm coming to the notice part, my lord. What was the judgment? We're rejecting, order, we're rejecting the application under order 9, rule 13, my lord. The operative part, I'm reading from at page 20, my lord. The court's view. What was the court's view, my lord?
Yes.
Page 20. Having heard parties, I have also gone through the case record of Manishut number so and so. The suit was presented for the first time before the court on 27/11/2020, and notice was issued with direction to be taken by the plaintiff with registered post AD on defendants. And the case was directed to be listed again on 15/01/2021. Accordingly, plaintiff is seen to have taken steps on 3/12/2020 on both the defendants through registered post AD. Again, another steps were taken on defendants on 19/01/2021 in compliance of the order dated 15/01/2021. 2 times steps were taken. Case was directed to be listed again on 17/02/2021. On 17/02/2021, the leave was granted for substitute service by paper publication. Then third time, the Honorable Learned Court has gave the permission to through paper publication. Whereas the plaintiff in compliance of the order had published the advertisement of notice on defendants in English Daily, Sentinel, as well as in vernacular language in Assamese, in Dainik Assam, of which both are the publication of Guwahati, where the applicant resides on 26/02/2021. In addition to that, plaintiff had made paper publication against the defendants in a local daily, and the address continued in the summon, advertisement in the paper publication, as well as notice in the execution petition are same. And before making order for substituted service, a considerable period had elapsed from issuing summon of third notice. Thus, the court is justified in arriving to go for substituted service against the defendant in its order dated so and so, though no reason is assigned. Further, the plea said set up by the applicant that until 25/02/2023, no summon was received by the applicant does not transfer confidence to be reliable, as the mode of service of summon in the execution petition is also through the registered post with AD, and in the same address of the applicant in which the summon were sent in Manisur through registered postal AD. And it is not the case of the applicant that address is wrong address for which summon could not be served. It was the same address in the original, so the summon was served. In the execution case, why they have appeared in the execution case when they receive a notice in this year for so-called notice for arrest and for the declaration of property, then they came up with this application for setting aside. And if your lordship have a look under the application file under order 9 rule 13, just they cannot go for the merit. They can only rely upon the notice itself. So my humble submission before this honorable court that enough chance was given to them, but they did not appear before the learned lower court. And now they came up with this baseless appeal, my lord. That is my humble submission.
Lordship, I may just point out something. There has been inadvertence. My office copy is corrected, but somehow the other copies have not been corrected. My office copy is the correct order 43 petition, Lordship.
Evidently, there has been some mistake.
Yes, some mistakes in the copies.
But what to do now?
I'll correct it, Lordship.
They have to withdraw them.
No, why
They have to withdraw first.
Court has a power to correct it.
They have to withdraw first, then the fresh application may be filed.
No, court has a power to correct it.
Because they are challenging both, my lord.
Yes,
They cannot challenge both under even under order 41 rule 4.
No, Lord.
They cannot challenge.
No, here's the mistake he's made. First, I have said, call for the records of both this and the title suit. And pending stay is for both.
I'm deferring, my lord.
Pending stay.
If there's already I have submitted, if they are challenging under 41 rule 1-2, then
he has a point, but she also has a point that her office copy, but we are not aware of the office
Yes,
copy.
Lordship, it's a why the impugn order dated this, as well as this passed in money suit should not be set aside. If this, I have written this, so order 41 would cover. Order 41 would cover that. Order 41 rule 1 and 2 would cover that. And this is necessary, why? Because everything is interlinked unless Lordship sees the records of the money suit. Lordship will not be able to find out whether there has been illegality in the title suit. Or even with this, I can file an
I
application.
think you'll be better placed if you withdraw and file a fresh.
So I'll just amend the cause title, Lordship.
That will be like changing the entire nature of the.
No, why?
Because you will change the sections and the orders.
No, I'll just change the orders. I'll add. I'll not change them. I'll just add one more. Read with.
the prayer rule would also be changed then.
No, why?
Why? I'm submitting before. Already I have submitted. If their application is under order 43 rule 1D, then they cannot challenge the original decree.
So it's up to them how
It's
they
up
want to
to-
amend.
I want to give both.
But if they want to add, then amendment can be allowed.
I want to add.
They only want to add one
No,
particular.
First, let them withdraw the case, my lord.
Why will I withdraw? Let him not dictate what am I supposed
No,
to.
no,
Let
I'm
him-
not dictating lordship. I'm not-
Let him not dictate.
I
Because-
don't have that courage. my
No,
lord.
no, not either me or the lordship. So I will just add. That's it. But lordship can still admit this for
He's
one
only
part.
suggesting to add the cost title.
My
Not the
lord.
cost title, they are to add a section or.
Section, only one section.
This is not maintainable itself and that, therefore my.
That will be decided later. Let her
My
That will be decided later. You
Okay.
decide later, you come up, we'll also have everything. Lordship, I'll just add this. Lordship may admit this. In the meantime.
Yes, what do you say about admission?
He
My
will not
lord-
object, he will not object.
No, I know lawyers object, my lord.
He will not object. He let him admit it, I'll correct it in the meantime.
I leave it to your lordships because I have the objection. That's why.
See, you have objected vehement. You will objected vehement, it's okay. So lordship, I'll correct it, I'll edit. I'll add both.
All right,
And
My
lordship,
lord,
I'll admit it.
my lord.
and
Stay
records,
stay may not be granted. my lord.
records, no
No,
lordship,
of course not. No, of course not. Stay cannot be granted.
records may be called for lordship.
Then the stay will automatically be granted if you call for.
Not
the-
short.
Can record may be called for.
Yes, can record, will call. for
No,
the-
lordship, other, if this thing is executed. If the execution.
There is nothing, my lord. Next date is fixed on 6/11, this November, for declaration of assets only. There
That
is
is a-
nothing.
Only for declaration of assets, then you have a long, they have a long
Yes,
way to go.
yes.
Then attachment, then publication, whatever. I think
But-
the procedure is a long
The
procedure.
procedures are long, but
Oh, but this is regarding money only.
it's money.
Money.
It's regarding money.
Not
Money.
land.
Money is not so long. It has been something. And lordship, even execution, so it's money. And who do they attach it against? Defendant number one is dead.
Let the scan copy come, my lord.
No, why?
Then court will decide
No, let
whether,
the original copy. of
because court will can go for merit also in that
the-
case.
No, lordship, let the original copy of the execution case come. Court will look at it once. Then court takes the next
Execution case only.
execution case.
Execution case.
I'm not getting it.
Only
Only
execution.
the execution case.
Yes, my lord.
Then that is the main case.
That is the main case, my lord.
So lordship, little much.
If your lordship stays it,
No, lordship calls it that one date. I assure you on the next day we will finish it.
lordship make call for the scan copy, my lord.
No scan copy,
Maybe
lordship.
fix a short date, because
Lordship interim stay in that. way.
on the month of 6th, in the month of November 6th, it is fixed only for declaration. Because
Only for declaration.
Only for
Short-
lordship,
Short date. Only for
Lordship,
declaration.
no, lordship,
next month, my lord, next month, any date
Only
fixed.
for
my lord.
declaration of assets, we'll call for the scan copies.
But declaration of assets, how lordship,
Yeah,
that
it will take time. A money suit, I know very well.
Yes.
It takes time.
no, it takes time, I
And
understand.
Lord, it takes time.
It takes time, lordship, but one small protection,
No, my lord, it cannot be.
one small protection in the meantime, lordship.
This error, this was crucial for you.
Yeah, it was, it was. It was, sometimes it happens, lordship, when you are hurried to do.
Can't help it now.
Yeah, I'll just amend it, I'll find
Yeah,
them.
sure. You can amend it, but no stay.
Lordship, I can't even give a, can you give me a minute? Lordship, will lordship allow me to correct this copy? I know the rules, but yet I'm making this abnormal prayer.
Cannot.
I know
Now
the
the
rules.
notice has been circulated, cannot.
I know the rules, but yet
Ah.
because you know the distance,
I know, I understand.
there's just the distance. And even the handwritten copy I could have
You do
given.
not have anybody helping you out from Arunachal Pradesh?
Lordship, this is a little complicated matter. Lordship, handwritten copy, a letter, a petition.
No, I don't think so. This won't work. It will go against you later.
Exactly, I
It will
know.
Go against you.
I know.
Then he'll come up with an objection against you.
Absolutely. So I know that, lordship, that's my problem. I'll try and do it. But can the advocate sign the affidavit? I think they can. Amendment of an advocate can. You don't need the client, do you?
Let's it go. Court is it.
Let the advocate sign lordship instead of the client. The affidavit.
I'll not pass any order regarding that. It's up to you.
I'll do it.
My lord, my name may be reflected in the cause of this, my lord,
It's
BM,
not reflected.
not reflected, my lord.
Okay. Heard learned senior counsel. Miss M. Hazarika, assisted by for the appellants, assisted by appellants, two appellants.
No,
Only
no,
one.
appellant.
For the appellant, assisted by learned counsel Miss S. Nevar. And learned counsel Mr.
BM Deka, my lord.
BM Deka.
Hi.
Victim number
My lord, 3.
3. Learned counsel for the respondents.
Yes, respondent caveator.
Now respondents. stroke
No, only one respondent.
Or respondent.
Respondent.
Caveator. You pass an order relating to the caveat. Oh, order has been passed, I believe, relating to the caveat.
Which one?
In
No.
this case, no.
No.
The name of learned counsel, Mr. B. Deka to be reflected in the cost list.
BM Deka.
BM Deka to be reflected in the cost list. So should I pass a long order or? I'll
Short
just-
order. I'll do it
Yeah.
right now. I'll
Yeah.
say,
So all these submissions regarding this and that,
And lots of
your
stuff.
submission not
not
required.
necessary. Lord.
The learned senior counsel has submitted that time may be granted to amend,
To correct the typographical error.
to correct the typographical error.
The.
It cannot be a
omission-
typographical
loss-
error.
The omission in the cost type.
Ah.
Omission in the cost type.
To rectify.
Rectify the omission in the cost type.
In the cost title. That is it.
And
Well, call for the scan copies of the LCR of the exhibition case number.
My submission may be.
13 of-
in that case.
No,
My submission.
his client is very up and doing, that's why he wants.
No, because since long, they have borrowed my money
Then I have
and
to
they
make my
have.
submission also.
Yes.
Yes, Raghunath.
ठीक है।
Let it be.
Okay,
It's not,
okay, Malcolm.
not important. Lordship. So Lordship will correct the omission and call for the scan copy.
I got confused by your submission, that is it. More than enough. I'm not even calling for the copies of the LCR.
My lord,
no?
my lord.
Call for the scan.
Lordship, we will rate maybe
Scan
6.
copies of the LCR of the execution case number. What is the execution?
13 of the execution is 13, no?
Case number
13 of 2000.
12, I think, 1 minute.
5 of 23.
5 of 23. List the
5 of
matter on
23.
21.
5 of 20.
5 of 21.
List the matter on 21.
Execution case number 5 of 23.
5 of 23.
Yes, my lord.
In money suit number
39 of
39 of 20.
In money suit number, yes, 39 of 23. 21. List the matter on.
Lordship will give a date
You
Convenient.
better when you can come to Arunachal.
whenever Lordship tells me.
Any date my senior is convenient.
Not this month, of course. This month you want to come?
No. Appunar jete convenient.
I record Ahiyo na paboto.
Shorter or longer?
Shorter Lordship. We are holiday the 6th.
From 6th we can accommodate from 6th.
6th.
7, 8,
8th?
8,
Maybe 10th.
10th. Okay.
10th is a Sunday, I'm not.
No, Friday.
10th is Friday. 10th is a Friday.
My lord.
10th.
Much obliged.
Oh. Yes.
Yes, madam. Madam, we kindly turn to page number 139.
Page number
193, madam, 193.
193.
3, madam.
Where did I keep the notes? Oh, yeah.
193, madam.
Page 193, huh?
Madam.
Yes. Page 193, yes. Yes.
My lord was asking for this, my lord, Pratap Tali. Pratap Tali, Lal Tali versus State of my lord. Actually, my lord, this citation 2015, my lord. SCC online Bombay 4083 is misquoted by Learned Court below, my lord. This is one I have placed this citation, my lord. That is Dilip Mishra Bang versus State of Maharashtra, my lord. This is not relevant to me, my lord. Pratap, this Pratap Lal Teli, my lord, and state also I have placed, my lord. That is a relevant, my lord. This is the citation, my lord, related to this case. This is 2019, my lord, Supreme Bombay 1529, my lord. Citation they have misquoted. Yes, my lord, this 2015 find place in this 2019, my lord. So Learned Court below has
This is
misquoted.
of State of Maharashtra.
Yes, my lord.
Okay, Bombay High Court.
Bombay High
The
Court.
High Court of Bombay. And where are the party's name? Pratap Lal Teli.
Pratap Lal Teli.
Misquoted.
Pratap Lal Teli is correct, my lord. State of, but this citation is misquoted 2015 SSC, my lord. This is the
Okay,
truth.
okay.
Now in Pratap Lal Teli also I have placed, my lord. Pratap Lal Teli, my lord, as this citation has been find place, my lord. According to misplaced, my lord. Now where I was saying, my lord, this citation favor me, my lord. Now what happened in this case, my lord? One person, my lord. Laws, I read the relevant part. Laws and FIR, my lord, under this section 19 of the Environmental Act, my lord. FIR, my lord. Now, as FIR no register, my lord, to this the person, my lord, for the port below magistrate, my lord, under 150 46, my lord, saying for direction registration FIR, my lord. That was rejected, my lord. That was again that person make a revision before the session court, my lord. That was also rejected, my lord. Thereafter, this
They came to the High Court.
High Court, my lord. Now, High Court say, my lord, that was correct, my lord. Yes, this is special bar under 19, as I was indicating the section 19 of the.
Okay, it's favoring you.
It's favoring. I read that, my lord.
Then why did he cite dissent? He
Misquoted.
relied on dissent, and why did he pass an order?
That was, my lord, this order is, my lord, misquoted. Totally, my lord, this is misread, my lord.
All right.
I will submit, my lord.
So where are the relevant? Oh, you have noted down the.
I am noted a pyramid.
And what about the Supreme Court judgment? This SCC?
No, this is.
Dilip Mishrilal
My lord,
Bang versus State of Maharashtra.
my lord, if my lord kindly look at 193, my lord, page number 193, my lord. This citation is quoted as reported in 2015, my lord. This is that's why I say citation means.
So this is not correct.
No, my lord. This find place in at my lord at.
But this is relating to Environment Act.
No, my lord. This is not relating.
This is relating to Environment Act. Yes.
15, my lord. 15.
Yes, relating to Environment Act. Town planning, then Environment Protection Act 1986, para 3.
Yes, my lord. Yes.
Relating to environment.
This also, my lord, find place. If my lord turn to the last page, last part, my lord, para, my lord. In the light of the discussion, proceeding CC number pending on the court the petitioner, my lord. This also favor my case, my lord. Yes, my lord. Law is clear, my lord. Under environmental law, in the policy, my lord, that is clear, my lord.
I have heard you at length. I'll pass an order later.
My lord.
This will be a long order. I'll pass an order later. I do not know what order I'll pass. I have heard you. I have understood you.
My lord,
That much I can say.
please give me 5 minutes. I like to simplify my case. My case is simple, my lord. Now it is the case, my lord, public servant, my lord, discharging while this a public duty, my lord. This is not disputed by the complaint in the complaint also, my lord. We were discharging our duty as per the sanction by the state government, my lord. Now they are simply saying, my lord, we did not take the environment clearance certificate and the forest clearance certificate, my lord. Now I am saying under the law, my lord, for construction of this, my lord, such type of road, there is no necessity of environment clearance, my lord. On the other hand,
That is at page 105 or 108.
108. Complement. I mean, case is simple, but there is no case at all, my lord. And apparently, my lord, on the report, on the complaint itself, my lord, if we go by their apartment, my lord.
So this case is pending at which stage?
Yes, process has been issued, my lord. We need to appear, my lord. Now, my lord will assume, my lord.
So you want stay?
Stay, my lord.
You do not want to appear.
Ultimately, we have.
But you will not be forwarded to custody.
That is true, but even then, my lord, while discharging a public duty, this is not a case of some like prevention of corruption, nothing like that, man. They also accept in complaint saying that yes, we have constructed the work, but they are saying we have not given them compensation, my lord. How, my lord, we are not the authority, my lord. For compensation, they have alternative remedy to file civil suit against the state government, my lord. What as an employee, my lord, that is to up to
I'll pass an order later. I'll pass it.
My humble submission, my lord, till returnable date, my lord, dismissed and on the
I have considered your submission. I do not know what order I will pass. I will have to go through the complaint petition also.
Yes,
Read the complaint petition.
complaint, my lord, with kindly note, my lord, there is in the complaint on the report itself, there is a manifest, my lord, vindictive, my lord. Saying they are claiming on the oath, they are claiming we have not given compensation. This land is our forest. Now, if these are their forest, there is where is the applicable forest land, man, forest act, man. Forest act, there should be some notification saying that this is forest. They are not disputing the fact this is their land, private land. On private, they are saying that private land you had not given our compensation. And after series of FIR, my lord.
No,
this is-
you see, that forest hills,
Ma'am.
some people are owners of hills and forests, no,
Yes, ma'am.
in Arunachal Pradesh.
Yes, the forest.
Not legally, but some forest or hills are allotted to them.
Yeah, my lord, normally in state of Arunachal Pradesh, my lord, in this native of these people are the owner of the forest, my lord. That is now that's why I'm saying if they are owner, for forest act to be applied, my lord, there should be a notification saying that this is a reserve forest. And in the complaint, my lord, they are saying no, this is not reserve forest. They are their private forest. Now, where is the applicability of this forest act, my lord? Forest act will be applied in the reserve forest, my lord. They are not. They are saying that this is our land, my lord. On the oath, my lord, I have indicated that
Okay.
on the oath, my lord. They are saying
I understood. You are saying that because the land is of, they are claiming that private land, so the forest act will not come.
not to apply, my lord. True.
So if the forest act won't apply, then what about this?
Of course, that's why I am saying, my lord, this complaint is misconceived, my lord. A vindictive, my lord.
Complaint stays, no? The complaint stays relating to corruption.
But process has been issued, my lord. Now I agree by that, my lord. And about the sorry, my lord, mental willity also, my lord, I some is a citation about mental willity, my lord. Whether this can be challenged under 430, 480, my lord. This is 2019, my lord. Issue was this was in 2009, my lord. Thereafter, in view of contradictory judgment, my lord, ultimately law was settled by full bench, my lord, in 2016, my lord. This petition is maintainable, my lord, against the issuance of process by the magistrate. This is maintainable, my lord. My humble submission is I have made a prima facie case, my lord. My lord will see, kindly be pleased enough to state a proceeding, my lord. And ultimately, the allegation against one aspect of I forgot to mention, my lord. The allegation, the cognizance, my lord, has been taken against the office, my lord. Office, like my lord, assistant engineer, chief engineer, my lord. Not by the, yes, we are holding that post, my lord. We have, I have made a category about it, my lord. We have by this application, my lord. That cognizance, my lord, process has been issued against the office, my lord. Chief engineer, my lord, PWD, executive engineer, PWD, and assistant engineer, PWD, my lord. Yes, we are holding those posts now, my lord. We are before this honorable court, my lord.
All right. I understand.
My humble submission, my lord, kindly.
Yes.
God bless, my lord.
Because I'll need some time to go through all those. I'm saying that we must block was this also. Yes.
Lordship, today on this post. So this is a joint petition filed by prisoner number 1 and 2 in connection with Itanagar PS case number 157.
Petitioner number 1 is the accused. or-
Yes, petitioner 1 is the accused and petitioner 2 is a complainant. Lordship, the incident was happened on 6/10/2021. First of all, let us go chronologically by that, then case will be very clear.
Clear.
It will happen on 6/10/2021 at New Zealand Village 1. New Zealand Village 1 incident was happened on 6/10/2021. Thereafter, FIR was filed on 7/10/2021 by petitioner number 2 against petitioner 1. In petitioner 1 is a land law, and petitioner number 2 is a rented lady along with her family members at New Zealand Village 1 here nearby, just the nearest campus only. Lordship, in this connection, FIR was filed that before the Oman PS Itanagar, and case was registered 157.
Where is the FIR?
FIR is para number.
Do you have an
Page
agreement
number
executed?
14, page number 14 of my petition.
Do you have an agreement?
Yes, they have a mutual settlement. That is annexure, what's it, annexure 5, page number
Five and page
52,
14, no?
52 page number.
This case is pending at which stage?
Charge order frame, now evidence stages.
Evidence stage.
Under section 354A1I/354B/324. The charge was framed under so order dated 6/12/2023.
Which page?
Page number 50, annexure 3 of my petition.
Okay.
Thereafter, on dated, Lordship, on dated 15/7/2023.
6/12/2022.
Yeah.
And
6/12. Yes, Your Honor.
9/7/2023, what do you have?
Lordship,
Evidence.
evidence, yeah. So evidence now, thereafter, subsequently we filed this joint petition before this one report.
Yes, do you have the LCR?
Yes, your lordship.
Yes.
Only at the stage of evidence, evidence haven't started, your lordship.
Haven't started this yet.
Yes.
So we can dispose
Yes,
it of
yes,
their
Yes,
worship.
Lordship, yes. And your Lordship, mutual settlement made on 17/7/23. And by presence of the village authority with their, along with their relatives. And it was executed before the executive magistrate, the MO. It is a settlement.
Settlement.
Yes,
that
that is
agreement.
annexure 5, 52 page.
Yes, I am.
Lordship,
Our learned council minister, so and so, for the petitioners and learned additional PP, TGD, Arunachal Pradesh. Learned additional PP, Arunachal Pradesh, Ms. TGD. The petitioners have jointly filed this application under section
480, yes,
with prayer for, with seeking
setting aside and
seeking to quash and set aside.
was and set.
Where is the prayer for, sir?
Page 16. Page 10. Page 9 and 10.
The FIR registered as ITA WPS case number 157/21. Comma, the charge sheet.
Charge sheet section, they have dropped from section. Learned Court law has dropped the section. They have searched 350. 354A1, A1I/354B/323. These 3 sections were charged.
Only the FIR, you have prayed to set aside the FIR only.
FIR,
Will quash and set aside the FIR, that
yes,
is suffice.
yes, Lordship.
My lordship, serial number for quashing of Even the GR number has been reflected, written. 3 and 4.
But squash and set aside a connected FIR number registered under sections FPC. Only the GR number has been written.
Yes.
So we'll set aside the
Yes.
FIR.
Let's see.
That will suffice.
Yes.
Lots, lots.
Proceeding will go.
Lots.
FIR of WPS case number so and so registered under
Also,
section.
this
So and
is
so.
my prayer for FIR GR case number 394/21.
Yes, yes.
And in my para here also I have mentioned.
No,
in-
no, no, only the prayer portion. Okay. It will suffice. The petitioner number one is the accused
Accused,
and he is the owner.
yeah, rent owner.
The allegation against the petitioner number one is that on 110, is it one?
Yes,
1/10/2021, the petitioner who is the owner of the
Lordship, 6/10/21.
or six. 6/10/21. Who at about 9 p.m. the petition number one, who is the owner of the resident let out on rent to the petitioner number two, called the petitioner number two and outraged her modesty. At present, both the petitioners have buried their hatchet and they have jointly filed this petition. You have you noted down, heard T. Ginny? Yes. The charge has, this case is pending at the stage of trial. Charge has been framed against the petitioner number one under section page 15. Huh? Which page?
354 A subclause 1I / 354 B.
354 A within bracket 1 within bracket Roman 1 I /354 B 323 IPC. Evidence has not yet commenced. Evidence is not yet recorded. The petitioners have also filed joint mutual settlement between them, which is marked as annexure 5 of the petition. As both the parties have mutually settled a dispute, it appears that possibility of conviction appears to be remote and bleak. Indeed, full stop. Indeed, further proceeding will be an abuse of the process of the court. I have perused the agreement annexed along with the petition. The petitioner number 2 has no objection if the petitioner number 1 is acquitted from the charges. Considering all aspects and considering the facts and circumstances of this case, I deem it fit and proper to invoke the inherent jurisdiction under section 482 CRPC. Hence, the FIR being the ETA WPS case number so and so, dated so and so, date not required. The WPS case number is set aside and quashed. Send back the, not,
No, sir, scan copy, it's
not required, send back.
Much obliged.
the
Please. Lordship, I'm appearing on behalf of PD Nair. On the last occasion in this matter, the delay continuation was filed and according delay was condoned. Lordship. So now the matter has been fixed for admission. Lordship. So notice may be issued at the state. Lordship.
Issue notice to the respondents, to register post with AD, reasonable.
Yes.
This is the matter of
May
petition.
I pray for that? Lordship.
Huh?
16 November.
All right, this is the matter on 16 November.
This is a statutory appeal.
Hmm.
I am challenging on two counts, my lord. The trial has been vitiated on two counts. One, section 207 of the CRPC has not been complied here with, one. And thereby, my lord, the right to fair trial under Article 21 has been violated by this. Second ground is, my lord, FSL report is still awaited. So therefore, my lord, this kindly admit it and issue notice.
Of course.
Yeah,
in IA, your lordship,
both.
both same.
IA and the
Yes, yes. I'd like to counsel for the appellant, Mr. Tiki Tara, and the learned addition PP, Ms. T. Gili. Learned addition PP, Arunachal Pradesh, Ms. T. Gili. So this prosecutrix is not represented. This is fixed for admission.
This is a new
Yeah.
case, new appeal, your lordship. This
appeal, my lord, it
coming
is
for the
always in
I'll
the.
admit, so we'll issue notice.
No, your
Issue
lordship, will-
notice, yes.
yes, your lordship may, yes,
Prosecutrix,
Yes.
issue appeal is admitted, issue notice to the respondent number 2 to register post with AD. Register post with AD.
No, no, this steps has to be taken by the registry in this case.
Acha, issue notice to the registry to take steps to issue notice to the prosecutrix.
Yeah.
Arrayed as respondent number 2, followed by the LCR. List the matter of when do you want?
after
Hmm.
4
After 4 weeks.
After 4 weeks, no. Much of that.
table.
Well, here I am challenging the judgment and order whereby I have been convicted under section 376 IPC.
That you have completed, no?
My lord,
You have completed that case.
no, no,
Oh,
it's
not
another
that
case.
So we'll admit it.
All right.
Admit it.
All right,
And then we'll issue notice, registry will issue notice to prosecutors.
all right. My lord, there is another IA. One IA is there. And
I
if-
also, we will have to issue notice to prosecutors.
Yes, the record has to come to consider the IA.
Let the record be called.
Record
LCR will call LCR also. Heard, Mr. S. Square,
Yes, ma'am.
learned counsel for the petitioner. Oh, yes, for the petitioner and Miss T. Ginny, learned additional AP. Arunachal Pradesh. The learned addition PP has accepted notice on behalf, oh, this is not notice this, so you have no issue, received everything, no notice and everything.
No, your lordship, no, this is the first time this matter is coming
Okay, the
up.
learned addition PP has accepted notice on behalf of the respondent number 1, so no formal notice, oh, that was also then it will be the first time.
The appeal has come for the first time, your lordship.
This sentence you add there also. The learned addition PP has accepted notice on behalf of the respondent number 1, so no formal notice is required to be issued. Stop, meanwhile, second copy to be furnished to the learned addition PP. The receipt to take steps to issue notice to the respondent number 2. Is the matter after puja vacation?
After
This
puja.
is the matter after vacation.
Your lordship, if I may, your lordship,
All for the LCR?
no, your lordship, even in this case, Your Lordship, at page number 3, the name of the victim is being reflected, Your Lordship. The needful correction may be recorded because even in the judgment, the victim's name has been spelled as Miss X, Your Lordship, since it has to be concealed in every possible manner, Your Lordship.
She is not a minor. She is not a minor.
The entire judgment was with regard to not even in minor case, Your Lordship, 376 case, Your Lordship. If Your Lordship will come to page number 17, Your Lordship.
Which page is the name of this?
17, Your Lordship, page number 17. Your Lordship will see even the judgment 17 of the IA, Your Lordship. 17 of the IA, Your Lordship will see it starts with on so and so Miss X. This rule even apply to victim of sexual assault now. Now, on many occasions, the Apex Court has clearly stated that even during service of the notice, Your Lordship, the name of the victim has to be concealed, and therefore services are normally done through the police, Your Lordship. And therefore, this in serial number 2, this may be amended, Your Lordship. Meanwhile,
Meanwhile, the appellant to redact or to
amend the page number 3
is directed to file an amended clause list
Without
without revealing the name of the victim.
Yes.
Applicable in this case?
Yes.
That is applicable only in the POXO case?
No, absolutely.
Everywhere,
it?
everywhere.
Yes.
All right.
Long time back. I think 1985, I did.
Yes, it has,
From
in
Bhumik's
fact, that
case, no.
376 years. It has been repeated, and even recently a guideline has been framed to that effect. Your Lordship.
It was held in that Delhi domestic health.
Yes.
No.
My lord, I beg pardon for the submission that I have made in the morning. Just before coming to this court in the afternoon, I had visited the registry. I found that victim is not required to be implemented as per your lordship's order. But in the morning, I have said victim as well as informant. They have to be implemented. So for that, I beg pardon from your lordship.
Oh, no problem at all. No problem at all.
Deep level.
Obliged.
Yes.
May I please, madam? Madam, this petition is filed by the joint petitioner, complainant as well as the
Husband, right?
joint petition.
Accuser,
For
complainant.
the petitioner number 1 is the complainant, who is the second mother of petitioner number 2.
Second mother of petitioner number
2.
2 herself is the second mother of petitioner number 2.
Yes, petitioner number 1 is the second mother of petitioner number 2.
Huh? Petitioner number 1 is second mother of
Petitioner number 2. And petitioner number 3 and 4 is maternal auntie of petitioner number 2.
All
And
related.
5 is maternal uncle of petitioner number 1.
Hmm?
Petitioner number 2. What happened, Your Honor, on
Petitioner number 3 and 4 are
aunt?
of petitioner number.
5 is uncle of petitioner number 2.
Petitioner number 3 and 4 are auntie.
Auntie of petitioner number 2, yes.
Petitioner number 2 is the petitioner number 1 is the second mother.
Yes, 1 is the second mother. What happened, Your Honor,
And what
on
about 5? Petitioner number 5.
petitioner number 5 is uncle of petitioner number 2.
What happened? What was the incident? Marpit.
Yes, Your Honor. Your Honor, yes. Your Honor, on 07/04/2022.
So charge has been framed.
Charge is framed, it is on appearance stage.
Evidence is what, under
No,
what section charge was framed?
451, 452, and 380.
So
451.
who are the accused? Uncle, auntie are the accused or the victim is the accused? Who is the accused? Here.
Accused is from petitioner number 1, from petitioner number 2 to 5, Your Honor.
they are the accused.
Yes,
Petition number 2 to 5 are the accused and petition number 1 is the second.
it's
mother.
second
She's
mother
the
of petitioner number 2.
defendant and the injured person.
Yes,
Okay. So now they have want to settle the dispute.
yeah, they
Yes.
already settled this, but I
There
have
there is
attached.
an issue with regard to this. Court has dealt with the issue on the earlier occasion, on 3 of the occasion, your lordship. What has happened in this matter was that if your lordship will come to page number 26, that is the relevant page of the charge sheet, your lordship.
Yes.
Your lordship will see in this
That names are.
names were different in the charge
wrongly
sheet. Your lordship.
inserted,
Subsequently, what has happened is they had filed an IA wherein this court was apprised of the application given to the judicial magistrate, wherein the police has submitted a corrigendum where the name of the accused were corrected, your lordship. On the earlier occasion, what this court has directed the accused herein is to get an update of it, because this corrigendum was submitted to the chief judicial magistrate. Now, this court wanted to know if the chief judicial magistrate has accepted this corrigendum or not, your lordship. That was to be brought
So
into record.
we still do not know.
We still do not know.
So we'll have
The,
to know. We have to know.
yes, now, if your lordship may
If
pass,
you
and-
want stay, then we can stay there.
no, your lordship, if
Cannot stay also.
because if stay is been granted, your lordship, the chief judicial magistrate will be stayed from even considering this corrigendum, your lordship.
Okay, yeah, that is true. All right, we'll wait for some time. She's correct.
This case is pending.
Once
since-
stay is granted, he will not move.
Yes,
CJM or C or he will
Yes.
not move.
your lordship, in that case, if otherwise I don't have any issues with
But
regard to
he's
this case.
actually, he's, I think, agreed because a long time.
Yes, yes, and
Yes.
therefore, your lordship may specifically make a direction today to what the chief judicial magistrate, if the chief judicial magistrate had taken into consideration the application dated 12/7/2023 submitted by the IO of this case with regard to the corrigendum.
Pardon, Mister?
My lord, at this proceeding may be stayed, you know.
No, cannot. I would have stayed, but the chief judicial magistrate, he will be hesitant. If this court stays anything, he or she will be hesitant and then it will go against him or it will go against anybody. So it will become something a jeopardized situation. Cannot stay. Heard, Mister
El Kagum,
L. Kalum.
Kagum,
Learned counsel for the petitioner and Miss T. Jenny, learned addition PP of Arunachal Pradesh. It is submitted at the bar that while submitting charge sheet, names of the accused persons have been wrongly mentioned by the investigating officer. To stop, this court by the order dated.
Yes, your lordship, is 23rd/8/2023.
23rd/8/2023.
Call for then updated LCR.
23/8, no?
23/8, your lordship.
Okay. No. Not 23, I think earlier maybe.
On 8/8/2023, on 23/8/2023, updated LCR was called for, your lordship.
Oh. 8/8/23, no?
Yes, lordship.
Call for an updated LCR on 8/8/2023. And thereafter, the IO has submitted a
Corrigendum before the chief judicial magistrate.
before the chief judicial magistrate that the names of the accused persons have been wrongly mentioned while submitting charge sheet. Then
Your lordship, if your lordship will come to page number 13 of the IA, your lordship.
page number 13 of the
IA.
Who is I? While order dated 8/8/2023. Was directed. While order dated 8/8/2023. Dated LCR was called to find out if the CGM of India has accepted the Korean submitted by the IU in connection with the erroneous charge sheet, in connection with the charge sheet, where the name was erroneously, where the names of the accused persons were erroneously inserted. So,
Now, what reminder may be given for update of the same order here.
but,
Yes, Your Lordship, even the court is upstairs itself, Your Lordship. A reminder to the registry. Because until unless this court is
issue reminder to not for the agency positively on next day fixed.
LCR, Your Lordship. Call for the updated LCR.
LCR. What did they say?
CD.
What CD? Updated LCR. Oh, yes. Positively on next day fixed.
Just after puja vacation.
Immediately matter on 6/11. Immediate. First day.
Much surprise.
Your Lordship, on for the petitioner, on for the petitioner, AD card is for the awaited,
What is your awaited?
AD card.
AD card,
Yes,
okay.
ma'am.
For respondent number 2.
Yes, Your Honor. Yes, Your Lordship.
Service of notice to respondent number 2 is awaited. List the matter on after application.
Okay. Oblige, Your Honor.
AB, issue notices.
My lord, I am also praying for interim.
Oh,
It's
no.
a contract, my lord. It's a contract, my lord. Kindly consider the FIR, my lord. If the FIR starts at page 10, my lord, and the relevant portion is at
No
page.
way, no way. I told you I'll accommodate all the cases of issuance of notices. So I
They have already
Kindly
been passed,
consider-
Lordship,
kindly
141,
consider
41A, Lordship. They did
Kindly
not,
consider
they did not comply 41A also, Lordship.
No, 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 no.
Kindly consider 2 minutes, my lord. Thereafter, whatever your
On
lordship
CD level
decides, I have
also.
nothing to say.
This is
My-
on your submission, I have.
My lord, 2 minutes, my lord. Thereafter, whatever your lordship decides, I will humbly accept, my lord. I have no other choice also. My lord, kindly come to page 14. Who am I? And what is my connection with the informant, my lord? If you consider that, my lord, perhaps things will be very easy to decide. I am a contractor, my lord, and I have been working for the informant. Now, what is the allegation against me? The allegation is, my lord, that I have taken 5,50,000 from him for
Item
the
number 26 only.
26 only.
But what about the other 27, 8, 9?
Those are not my matters, my lord. Those are different matters, my lord. Mine is totally based on contract, my lord. The allegation, if your lordship come to page 14, that is the FIR, my lord.
Please,
And
please. read that.
it is to inform you that I am a contractor by profession and I have undertaken construction of new district hospital building at Bomdila. I have engaged one Jahirul Islam, permanent resident of village so and so for completion of works connected with painting, false ceiling, installation and fixing of aluminum doors and windows of the district hospital Bomdila. Earlier, I used to purchase false ceiling, aluminum and other building items from a hardware shop called Padmapati Aluminum and Hardware, Bhetpada, Charali, Guwahati. Sri Jahirul Islam came to me and told me that he has known one hardware shop at Guwahati which gives false ceiling, aluminum doors and windows items at a very cheap rate. Sri Jahirul Islam gave the name of hardware shop owner as Sri Rajan Das and introduced him to one of my construction partner, namely Sri Sunil Cheda, over phone. Sri Rajan Das told my partner that he runs a hardware shop at Guwahati in the name and style of FS Enterprise and sells the items at a very cheap. Amounting to rupees 5,50,690, being the lowest rate for the items. On 22nd of September 23, Sri Jahirul Islam came to me and told me that the invoice items were already loaded in a vehicle for transportation to Bombdila from Guwahati.
So why,
And-
how can, I have read it, the entire FIR.
My lord,
So how
my
do you
lord,
deserve?
two things I would like to highlight. My lord.
Deserve this interim,
That is what I am trying to impress upon my lord. One thing is quite clear that the person informant is a contractor and he has also engaged me as a subcontractor to work under him, giving me certain assignments for making of false ceiling and installation and aluminum doors and paintings. Now, my lord, this relationship has been continuing for 1.5 years. I am now to get rupees 27 lakh from him. The 5,50,000 kindly come to next, the reply that I have. Kindly consider, my lord, the next page, page 15. Last but one paragraph. The way amount was taken out from me shows that Sri Jahirul Islam never intended to complete his works. That means I have been doing his works, but now after 1.5 years, he has realized that I have no intention to complete.
So
Now,
have
my
you,
lord,
if you have given him 22 lakhs, have you?
I have to receive, my lord. I am not to
So,
give. I have
Have
to
you
receive.
filed any FIR?
My lord, kindly come to my reply that I have sent to the police in this regard, my lord, page 20. And I have also written to DGP. I am ready to cooperate, my lord, provided I am given the protection, because once I go to Bombdila, I have life threats. Now kindly consider my reply, my lord, to the officer in charge in response to the section 41 notice. Para 1.
This will not work.
My lord, kindly consider for a moment. Para 2, if not the entire relevant portion. Sir, I am a contractor by profession and engage myself in different activities like false ceiling, paint, door, window, etc. I have engaged in different government and non-government related contractual activities in the state of Assam as well as in our neighboring state of Arunachal Pradesh. In the month of February 2022, the proprietor of Messrs. TD Enterprise, namely Norbu Deru, had told to me that he has been allotted the contractual work for construction of new district hospital building at Bombdila. The necessary construction of the building was completed and the works like false ceiling, paint, door, etc. are only left to be done. He offered me to carry out the said activities in respect of said construction hospital, in which I agreed for the same. For the last 1.5 years, I have engaged myself in the said contractual activities allotted to me by said Messrs. TD Enterprise. I had deployed my main power of around 25 numbers of labor at my own cost in the constructional site. I have obligation to make the payment to the engaged laborers in time, since the laborers are leading their life as well as maintain their families through their day-to-day earning. To pay them, I need my money, my payment too by the employer Messrs. TD Enterprise. I cannot stop myself from making payment of their legitimate dues. The proprietor of Messrs. TD Enterprise, namely Tenzing Norbu Deru, had assured me to pay my bills. My lord,
Yes, I'm ready.
my lord, what has happened? What I had done? He paid me out of 27 lakh, he paid me 5,50,000 to purchase certain items. I say in my response, my lord, that I have adjusted this amount against my pending bills, which I have a right. I have set off this amount. I am not saying that I have not taken. I accept that I have taken this money, I have set off. Now he is saying that I have run away. I have not run away. I am ready, but you pay me the remaining amount. You are ultimately, basically, it's a civil dispute between me and the informant. But in order to extract the remaining work to be done, he is forcing me, my lord. In this regard, my lord, before your lordship takes any decision, I'd like to cite one judgment where the Supreme Court has.
No, but this is not.
My lord, for a moment, for a moment,
You told me no.
my lord, for a moment, the head not only this adjustment part, the set of part.
Taken it up. This is not done.
So in interim protection, my lord, till the next date, my lord. Ultimately, my lord, I am
So,
living
Lordship, I'm
at,
objecting, Lordship, this interim protection, Lordship, because here the private place will establish that there's 420 is well established as well as 379 also, Lordship. Lordship, here, Lordship, the complaint is made against the two accusers, Lordship. There are another accuser also there, Lordship. If one is getting the this interim protection, other will apply doctrinal parity, then he will automatically get the protection, Lordship. So that, Lordship, for 41A also he did not comply. Instead of, Lordship, appearing, Lordship, he just submitted one, Lordship, this what is they call, Lordship, this statement, Lordship, to the OCS. This is not done, Lordship. So is this also he's absconding, Lordship? Vehemently he's absconding and he's not cooperating. So, Lordship,
I am ready to cooperate, my lord. I am
No,
not
Lordship,
running
it
away from my
appears that
responsibility
he's
since
not
I
at
have
all
receivable,
cooperating,
my
Lordship.
lord. My lord, for a moment.
41A also, Lordship, he can appear before the IO, Lordship. Event of that, Lordship, he maybe he could not be arrested because 41A is not like that. He should be arrested, Lordship. He's just to.
I am ready to visit, my
No,
lord.
no,
I am ready to
now
visit.
he's over.
Mere petition will not do.
My
You
lord.
have not lodged any.
I am ready, my lord, if I lodge
Not
any
a
FIR,
civil
if
case.
I am to lodge any FIR, my lord, I will have to visit Bombdila because the cause of action has arisen there. Whether I will return back safely, my lord, that is a question. That is the practical question, my lord.
Only, Lordship,
He is
CD may be called
most
for,
powerful person there. I have taken the foolish decision of working for him. Now I am running for my own safety, my lord, and it's not that I am running away from my responsibility. The Supreme Court says you can adjust the amount, and if you adjust the amount, because I am not running away, if you adjust the amount, my lord, for a moment, if your lordship see the head note only,
No, this is.
I can understand. This is in regard to criminal case, my
So
lord.
this
This
is
is in regard.
randomly submitted. How can I say that you?
I am saying, my lord, that you are to pay me
How can
27
I
lakh.
believe that he is true and that contractor is not, that informant is false. How can I believe?
No,
This
no, my
is
lord,
randomly-
informant has only said that he has engaged me.
Have
I am
you-
working for him.
Have you given any receipts of payment of labor? Anything, nothing?
I have one pen drive, my lord. We have craved for the liberty to produce the pen drive. The recordings of the voice of the informant, his wife are there. If your lordship
No,
allows me, I
see,
can.
you have said that you have paid for up to 20 lakhs. Just vaguely, you cannot say you
No,
have
my
given
lord.
me receipts, how much?
My
you
lord,
have
then
paid.
kindly give me some protection till
No,
the
my
next
lord,
day. In the
lordship.
meanwhile, I will produce, my lord, and I have brought the pen drive. My lord, I have produced, I have brought the pen drive. If your lordship permits only
If
for
you
2
if you
minutes.
want protection,
We have
then
written,
submit.
we have spoken about the pen drive, my lord.
If you want protection, see, these are vague submissions without any receipts and all.
No, my lord.
Up to
My- I'll-
27 lakhs, you have said something.
Yes, my lord.
So up to.
And that
27
is
lakhs, up to
apparent, that,
22
my lord,
lakhs.
that is,
At least you must produce some receipts.
no, receipts, the laborers don't ask for receipts, my lord. There is one thing my lord will appreciate, my lord will appreciate.
Without
that the-
anything, without any evidence.
I can understand, my lord.
Up to 27 lakhs payment register.
Okay, my lord, let us assume only for 5 lakhs. Ultimately, he has admitted that he has engaged me. He has also admitted that he is getting work done from me. So at least this shows that I am working for him. Without money, I am not working for him. I am to get some money. So whatever dispute has arisen, ultimately it relates to money in regard to payment of money. Can there be any FIR, my lord, only on that count?
No, I'm not asking for FIR.
No, my lord,
I'm
can
asking
you-
for receipts. You are.
my lord,
submitting
let us
receipts.
forget for the moment, my lord, that I am to receive 22 lakhs.
So I will
But
not
one
sit
thing
and-
is,
I will not sit and argue with you.
no, my lord,
Yeah, but I'm not convinced.
my lord, kindly consider the FIR itself, which shows that he has engaged me.
No, no.
And I am I am a
It's
contractor.
your duty to convince me. I'm not convinced. Sorry. to say.
I'm sorry, my lord, if I have failed in my responsibility and duty, my lord. But I am trying to convince, my lord, only 1 minute, my lord.
We'll
One
only
thing,
call
one
first.
thing my lord will appreciate is quite clear. The FIR itself shows that a relationship is there,
No,
and
no.
that is, he is the contractor.
I'm not read into much of the FIR. What I have seen from the FIR, what I could call out is that you have cheated him.
No, my lord.
That is what I could
What
call
he
out.
said, my lord, that he paid for the purchase of articles and materials, which I have not done. I am saying that I have set off against my pending dues. And I am still saying in my response, my lord, that I am ready to go, provided 2 things I am asking for. One, you agree to reconcile with the accounts, number one. Number two, you give me the security because now you are so angry with me that you are not allowing me. You have engaged the police to chase me. I'm not running away, my lord. Otherwise, why I would be here before this honorable court, seeking protection so that I can go. I undertake the responsibility to appear before the IO in person if that is what is going to satisfy the prosecution. If my answer is not sufficient, Satyendra Kumar Entil doesn't say that you have to remain physically present. I have responded. That at least prosecution will appreciate.
We'll go to CD. After that, Lordship, if next date, if it will be considered.
Till then, my lord,
No,
till then.
Lordship,
It's
not
not that-
at this moment, Lordship. We don't need
That
a
is what
CD,
I'm saying, my lord. The prosecution will appreciate, my lord.
Yes, meanwhile, through an affidavit, you can submit whatever expenses you have incurred.
Definitely, I will. do, my lord.
Meanwhile, I'll call for a CD only.
My lord, kindly give me
No,
the
Lordship.
More convincing.
only till the next date, my lord. I am not.
Listen to me, I'll pass an order. If you are correct, you just, if you do not agree, then I will cut it.
No,
I'll strike it.
no, my lord, it is
No,
up to you. Whatever your lordship
You
thinks.
just listen to my dictation. If you find it okay, then I will continue with the order, and if you do not want.
My
to-
lord, I will gracefully accept whatever your lordship says.
I'm asking for your help.
Okay, my lord.
Seeking your-
I will do.
Yes. Heard Learned Senior Counsel, Mr. Tiwari,
SK Singh, my lord.
SK Singh, because I have heard them referring to you on, in this meeting. that-
Singh, my lord. Singh from Tejpur.
Yes,
And
yes.
his
That
lordship,
much I have-
just for a moment, his lordship was there as a district and sessions judge. That is
Okay.
why we are personally
that-
acquainted with each
that-
other.
That much I could grasp, that you were a senior lawyer from Tejpur.
Tejpur, my lord.
Heard Learned Senior Counsel, Mr. SK Singh,
Ah,
assisted by Learned Counsel, Mr. P. Nath. Heard Ms. L. Hage, Learned Additional PP Arunachal Pradesh. Call to consider the bail petition CD is necessary. Call for the CD. The Learned Counsel for the petitioner has submitted that. Is it okay? Has submitted that on the next day, the relevant documents relating to
Pen drive, my lord, because
Relating
it's
to-
very difficult to give it audio and
transactions of the contract.
shall be provided in a pen.
Relating to transaction of the contract and subcontract between the petitioner and the informant, will may be submitted on the next date fixed. And the matter of interim stay will be considered after the submission of the additional application. Is
My
it
lord,
okay?
my lord has given me the liberty to intervene. And taking advantage of that liberty, my lord, may I say that kindly give me the interim protection?
No,
till the
Lordship,
next date, my lord.
kindly no, Lordship. At
Your
least
lord-
suspend, no, Lordship. And Lordship, it may be.
Your lordship
later after vacation.
gave me the Brahmastra, my lord. If I am to allowed, my lord, to use
Whatever, any digital form or whatever, you can submit the documents.
And Lordship, it may be
till
discussed
the
after
next date, my
vacation.
lord.
Huh?
My
After
lord will
vacation.
appreciate. It's not easy to
Yes,
go
sir, but-
for Jahirul Islam to Bombdila without any interim protection. That is the real fact, my lord.
So you.
The
need
ground
not come-
reality.
So you need not come. I'm giving you time. This hiatus or gap.
In the meanwhile, in the meanwhile, if no coercive action is taken from the IO, I am ready to cooperate, my lord.
Lordship, the FIR laws is 23-9, Lordship. Till now, he's absconding, Lordship. He can manage some more.
No, no, I
4
have
days,
already
Lordship.
responded. I have already responded, and I am again, time and again saying that
Lordship,
Satyendra Kumar
then-
Entil doesn't say that I am to remain physically present.
For the payment register and all to the IO. Meanwhile.
Payment
As an
register,
additional reply forward under notice 41A for the additional payment register and all, and the receipts
That-
for purchase of articles and all to the IO.
my lord, may
This will
I
help.
have
you a lot.
already sent the pen drive, that is what I have already written, my lord, will appreciate in
No,
the
this-
response, my lord. I have already sent it to the IO,
No,
the
no.
pen drive.
This will not suffice. The pen drive will not.
Pen
suffice.
drive, my lord, it contains the audio and
Actually,
video, my lord. How audio and video cannot be
But,
transcripted.
Receipts and all are submitted, about purchasing
my lord.
materials and all, we grant interim relief. If it is submitted, usually whenever receipts and all are submitted,
One more thing I
we
would like.
usually grant interim relief.
Suppose,
But
my lord, what
there
is the?
nothing to support your case.
My lord, what is the allegation that I have taken the check? Am I denying? Now, what is the necessity of
No, it-
custodial, my lord, what is the necessity of custodial detention? If I have taken the check, it will be through bank that you will have all the documents in proof. Nor I am denying. I am saying that only that I have adjusted it, set off it.
If you
That
send those,
explanation,
what
my-
I'm saying, if you send those to the IO,
I have already
then
sent.
it will come.
I have
along with
already
CD.
sent. I have already sent, my lord.
It will come along
In
with
response,
CD.
along with a pen drive, that is what I have referred to also, my lord, that I am sending a pen drive, my lord.
Yes.
My lord,
Lordship, next date, Lordship, after vacation.
kindly fix
Date,
it.
date.
Date.
Immediately after the vacation, if you can.
Kindly fix a date. my lord.
When do you want it?
Till the next date, I will remain in anxiety, my lord.
You can Delhi very well from from 2000, what was the date?
9 November, the my senior counsel is asked.
You can manage to Delhi.
9 for 10, 9.
9 November.
My lord, till the
9.
next date, my lord. I am sorry for time and again
Very,
praying.
very, very sorry, no. Okay.
Your Lordship, prior to any submission being made in this series of petition, all are connected matters, Your Lordship. Lordship will see that all these criminal petition. All these bail up.
Farmers case, which was the item number, farmers case. I want to just take out the cause list. 21, no? Item number 21, because I have to pass an order in farmers case.
Right.
Okay. This one, no? Admission stage, motion stage. Okay. With the recording, send it inside. Yes.
Your Lordship will see as per the rule, why the notification, Your Lordship, of 2001. That all the bail application, if not by the petitioner, has to be done by the relative by an authorization letter, Your Lordship.
Where is it?
Down below, Your Lordship will see notification dated.
22/6/21.
Yes, Your Lordship will.
It is computer.
Your Lordship, I have annexed the letter of authority. I have annexed the letter of authority.
Just for copy.
Just a copy. Its letter of authority is there, Your Lordship. So
It's not annexed in my petition, if I may.
CD may be called for.
Call for the CD, list the matters on.
Six.
And next letter of authority.
No, where is that?
Yes, it's there.
It's there, I could not find any.
Yes, letter of authority, yes.
We have, Your Lordship, for all the accused, Your Lordship.
Yes, for the accused, or for all the,
I see Pannai, Wangpan.
yeah.
He's an
Pangai,
accused.
Pangai Wangkan in Dajen Wangpang,
In all the accused, I have annexed the letter of authority.
Lordship, Your Lordship may
I have
kindly,
only one.
Your Lordship, in this,
There is 5 more petition.
in some of the petition,
Separately
I am
filed.
not able to find, yes, don't know.
So why the accused themselves could not find them?
They're inside the jail. They're at Longding police station. Earlier they had moved
Where, what is Longding?
Longding, it's I think 300 kilometers away. It may be listed on 6th of,
Your Lordship,
I found only one. In this one, I have found only one.
separate in all the separate petition, the letter of
But
authority.
she's not fine.
but I'll just check once, I'll
I think
check
she
all the
might have
petition, Your Lordship, because
also-
otherwise it won't be maintainable per se.
Here I have found her. I can show it to her. In lower courts also, that accused need not file.
Yes.
In relatives can file.
Yes. But
But
they,
here High Court, I
They-
think you need
they'll
to
have-
Yes, otherwise it will
They-
not pass the registry. You also. Letter of authority needs to be annexed, otherwise they will reject it.
Registry will
Yeah,
not,
yes.
yes, it's there in the last page, not numbered, only in the judge's copy, Your Lordship, it's there.
No, they should get one copy. Why you are not getting the copy?
I have not got any, it has not been annexed in my.
Why you have not given a copy?
Your lordship, actually only it's needed in the judge's copy.
PP has to know about it.
It has to be annexed along with the petition, Your Lordship.
You ought to have given her a copy.
Yes,
Her or him, whoever.
yes. Actually, I was furnished only one copy from Longding. So therefore,
Xerox.
You can Xerox it.
yes,
Always.
that might be, may consider your lordship.
Oh, that accused will not sign on the copy.
Yes,
You can always Xerox it.
yes.
All right, then call for the city.
Yes,
Better
Lord.
after vacation.
Six, on six, your lordship.
Ah.
Yes,
On 6.
yes.
Already on
Yes,
6.
Your Lordship.
Oblige.
Deeply.
11 to 13, no one is present. Huh? The matter is fixed for orders or admission? Orders. Huh? Matter is fixed or orders, then we can. What was the last? LCS received from special judge. So we can admit it for hearing then. Or we can admission then. For hearing. Nobody is present for hearing.
I'm sorry, 11.
Not for orders, for hearing. Because it's already time, time is already, it's 3:30, we will sit down for hearing.
Your
It's
Lordship,
already 3:30.
it's already in the supplementary hearing, Your Lordship may observe the absence of the council and fix it after vacation.
The PP is on the other side.
Yes.
All
We are,
cases.
we are just a performer party.
Petitioners are not represented. The learned addition PP, Miss T. Jenny is present. List the matter after vacation.
Yes, Your Lordship. Deeply.